Well, after the Bronco left Vertel's, I think it was about a month later, it went to a more secure location, and at the request of the defense, an examination of the Bronco was conducted in their presence. And Michelle Kessler told you of how she saw that Dennis Fung had not collected all of the blood off the console. And she said, let's collect the rest of it. So they took the console out, and Greg Matheson actually swatched the remaining blood off the console in the presence of the defense experts. And that was on, I believe, August 26th, either August 26th or September 1st. Now that blood that he swatched on either August 26th or September 1st in the presence of the defense did not go through LAPD testing at all. That blood went straight up to the Department of Justice for testing. And it came back with an RFLP match that you heard late in the trial. RFLP meaning we had more DNA in it. And we were able to say, we were able to match the blood again to the defendant and Ron Goldman. That's very important for two reasons. Number one, it shows you that it is not so easy to contaminate DNA. It's not so easy to contaminate blood. Even though that console sat there in the Bronco at Vertel's, where everybody had to go and check this Bronco out, the results that were obtained on the morning of the 14th before it went to Vertel's are the same as the results that were obtained about 2 months later, 2.5 months later. So it tells you also that PCR testing is accurate. But of course, even more importantly, it tells you that Ron Goldman's blood is in that Bronco. And there's no reason for his blood to be in that Bronco, an RFLP match, unless the defendant committed the murders and had the blood of Ron Goldman on him to swipe on that Bronco. Now there's something else about that Bronco that I wanted to point out to you. On the driver's side of the floor mat, where a driver would put his foot, we find a bloody imprint. A bloody imprint that Mr. Boziak told you had characteristics consistent with the Bruno Magli shoe of that S pattern that he talked about. And a bloody imprint that was tested and matched to the blood of Nicole Brown. That carpet piece was cut out of the Bronco by Dennis Fung on June the 14th at the print shed. Now, think about this one for a minute, because just the fact of having blood in that location tells you something. How in the world do you get blood on the floor mat in a position where a driver puts his foot unless you have stepped in blood and then sat in the car and put your foot on that spot? How else? How else? How many times have you stepped in blood, and how many times have you tracked it into your car? I don't know how many, but you can see just logically somebody who is walking around with bloody shoes gets in to drive his car, and the carpet comes up. There you go. And this is People's?
It's on People's 172.
People's 172. Thank you.
Thank you.
I'm going to ask Jonathan to point it to you. It's, you can probably see it though.
Do I use the laser?
Oh, great. This is easier. Look. See right here? And that's what we had testimony about with respect to the blood testing and with respect to Mr. Boziak. But when I sat and I listened to that, I thought, gee, I don't know how much clearer it could be. I really don't. You have the blood. You have the bloody shoe prints going down the walkway. Understandably, on concrete, a hard surface, they fade out. Then you put that same bloody shoe that obviously got blood up in the grooves of the pattern of the shoe onto a soft surface like a carpet that picks up that blood, whatever's remaining. How else did it get there? And those bloody shoe prints that lead away from the bodies of Ron and Nicole reach right into the defendant's Bronco. You can already see we have such a wealth of evidence. that we could probably stop right here, but frankly, I'd like to, but I have to finish going through all of the evidence, and the Bronco went back to Rockingham. So let's go back to Rockingham as we trace the steps. And I'll quickly review the evidence for you at Rockingham. So he gets in the Bronco and he drives back to Rockingham, parking it on Rockingham, just north of the Rockingham gate, where we see it in all of the photographs. Now, as I've described earlier, the defendant runs down the south pathway, and you're thinking to yourself, why? Why would he do that? And I talked to you about disposing of the knife. Really common. Murderers want a weapon. They think that's the one thing that can nail them. He's running back to that rear lot. He never gets there because he crashes into the air conditioner, dropping the glove. Why would he need to put the knife on his own property? You're thinking, why not drop it in a dumpster on the way home? Doesn't that make sense? Why not? Why would you want to do that? Leave it on your own property or bury it on your own property. He can't. He can't because he's famous. If someone sees him hanging around near a dumpster on that night of all nights, at that time of all times, dropping something into a dumpster, they're going to recognize him. And he's going to have a witness. A witness who's going to put him very close to the scene of the crime at the very wrongest time he could be there, right after the murders. He can't dispose of evidence in public. Every move he makes is noticed. So he's got to find a private place, and that's the one that makes the most sense. And he doesn't have a whole lot of time to get real creative here. So what do we find on the Rockingham glove, the one he dropped? We find everything. Everything. We find fibers consistent with Ron Goldman's shirt. We find the hair of Ron. We find the hair of Nicole. We find the blood of Ron Goldman. We find the blood of Nicole Brown. And we find the blood of the defendant. And we find Bronco fiber from the defendant's Bronco. We find blue-black cotton fibers just like those found on the shirt of Ron Goldman and on the socks of the defendant in his bedroom. And on this glove, he is tied to every aspect of the murder. To Ron Goldman, to Nicole Brown, to the car. And of course, that's why the defense has to say that the glove is planted. Because if they don't, everything about this glove convicts the defendant. Where it's found, what's found on it, what's found in it, even a black limb hair found inside the glove. Everything about it convicts him. Even though the planting theory is ridiculous, when you think about it, you give it a little rational thought and you realize it's absurd. Whatever you think of Mark Fuhrman, nobody thinks much of him. He couldn't have done this. Why couldn't he have done this? It's not just the fact that all the other officers who were there before him saw only one glove. Think about what he knew at the time he went out to the South Pathway. He didn't know whether or not there were eyewitnesses to the crime that would say somebody else did it. He didn't know if there was going to be someone who said, I heard voices. They weren't his. They weren't Mr. Simpson's. He didn't know if the defendant had an airtight alibi and had maybe left on the 9 o'clock flight to Chicago. He didn't know any of that. What he could have done by planting evidence has been wrong and completely fouled up the solution of a case, because he's doing something like that without knowing anything about the case, subjecting himself, think about his own self-preservation, to an incredible felony. He's in big trouble, and all that has to happen is that an alibi is proven or an eyewitness comes forward, neither one of which he knows anything about. They could be out there for all he knows. He probably thinks they are. So think about that when you consider this theory of the defense. You know, I mean, it's like dismissing logic and reality and reason all at once. Throw them out the window. Because nothing makes sense about that theory. Nothing from even Mark Fuhrman's point of view. But I think if you look clearly at the evidence, if you look straight on and you use your common sense, you're going to see this. You're going to know this. You will. But the bottom line is, and I think that you'll reach the same conclusion, no one planted that glove. You know why? Because they're his gloves. They're his gloves. Think about all the evidence you've heard now. Remember that he's a size extra large. The gloves are a size extra large. The glove at Rockingham is a mate to the glove at Bundy. They're a pair. A pair that are the same exact type purchased by Nicole on December 18th, 1990. One of only 200 pairs sold that year. Gloves that are cashmere lined. Gloves that cost $55. Rich man's gloves. Gloves that were exclusive to Bloomingdale's. Gloves that were not sold west of Chicago. Gloves that the defendant was wearing at football games from January of 1991, just a few weeks after she bought them, until the last football season before the murders. Now, you'll recall that there was a photograph that was shown to you. First of all, the receipt. There was a receipt that was shown to you that showed that when she bought the gloves, she bought 2 pair of gloves and a muffler on December 18th of 1990. And there was a photograph shown to you during one of the football games that I'm trying to remember the date of. I think it was 92. I think it was 92. In which he's wearing a brown jacket, a brown muffler, and the brown gloves. Doesn't it make sense that when she bought the muffler, she bought it to match at least one of the pair of the gloves? And there he is wearing it. And you see him wearing those gloves in the photographs that we showed you right up until the last football season before the murders. And the gloves you saw him wearing in all of those pictures that we showed you at all those football games are the gloves that you have right here in evidence in this courtroom. You have testimony that was taken on this photograph. You see the muffler, the jacket, the glove.
Mr. Farrell, what exhibit is this?
Exhibit 614.
Thank you.
I think it was January of 92. If you need to have that reviewed for you, it's in the testimony. Okay. Now, I know that you recall the glove demonstration when the defendant put the gloves on, the crime scene gloves on. Now, he mugged for you, and he tried to act like it was real difficult, it was real hard for him, and almost impossible to get it on. Well, I'm sure it wasn't as easy as usual. He didn't have to ever wear them before over latex gloves. As Mr. Ruin told you, that makes it a great deal more difficult to put gloves on. And being old gloves, the blood that soaked into them soaked in and made them that much less stretchable. Because really the issue is stretchability, not so much size. If he'd had the chance to put them on, wear them for a while, they would have stretched back out. They would have been a better fit than they were. So it might have taken a little effort and a little time, but you ultimately would have seen that of course they do fit. And it's no different than the experience that we all have in our lives. You have leather gloves, they get damp a little bit, you leave them to dry, you don't wear them for a while, you go back, you put them on, they're tight. They're tight. You got to drag them on, pull them on, you wear them for a little bit, they stretch back out. And that's, again, that's common sense. That's something that we've all had in our life experience. But if you're really trying, of course, you can do it. But have you ever tried to put shoes on a child that doesn't want shoes put on them? Or a jacket on a child that doesn't want the jacket to be put on, you know, you can't do it. They're going to kick, they're going to scream, they're going to avoid you, they're going to struggle, they're going to squiggle, and it's not going to happen. Now that's the same thing we have here. He doesn't want to put those gloves. He doesn't want to show they fit. But did you see how quickly he snapped them off? If they were so hard to get on, how come they came off like that? And they did. And I'll tell you something else that really struck me. If I were asked to put on the gloves, the bloody gloves that were used to murder the father of my children, I would not be laughing. I would not be mugging. I would not be playing games. I wouldn't think it was funny at all. Is that the attitude you expect? The laughing and the mugging? Putting on the bloody gloves that were used to murder the mother of your children?
Sustain. Move on.
Okay. The point here is that the person who wore those gloves wore size extra large.
In fact, let me see counsel side over quickly.
Now, the testimony has told us that the gloves in evidence are smaller now than when they were new. So the issue with all that has been done to them, blood-soaked, frozen, unfrozen, who knows what, the issue is how they fit at 10 p.m. just before the murders on the night of June the 12th. The issue is how stretchable they were then, before the murders, at 10 p.m. on June the 12th. And we know that those gloves fit him on the night of June the 12th because he wore them, the size extra large, the size you know fits him because he put on a new pair of extra large here in this courtroom. As Mr. Rubin said, they fit him beautifully. And he did that, of course, without the benefit of latex, and I say benefit sarcastically, latex to catch on them. So you have in these gloves all of the points that I've described and as shown on the slide. And another piece of the puzzle. Now let's move back down the walkway, the south pathway that is, that dark, narrow south pathway. And when he ran back down there, the defendant undoubtedly saw that the limousine was already there because it was pulled up facing into the driveway at the Ashford gate. It would be hard for him to miss. And he knew that he should already have been home. He was running late. And don't forget, you know, he's pretty shook up at this point. He's run into the air conditioner and banged into the wall. He's worried, got to be worried, about the fact that Cato's going to come out and worry and try to investigate the source of the noises. And he's got to get out of that south pathway because if Cato sees him back there, how's he going to explain that? How's that going to look? On the night of the murders of the wife and Ron Goldman, if Cato comes outside and sees him in that dark south pathway, what's he doing there? So he's got to get back in that house, and he's got to get back in a hurry. Which is why there was no time to hide the knife behind the guest house. He had to get out of there. Which is also why there was no time to realize that he'd dropped a glove. All right, so he goes into the house, which is where at the point that Alan Park sees him go in, which is a couple minutes after the thumps are heard by Cato. The defendant went upstairs quickly. He answered the intercom when Alan buzzed him this fourth time, I think. And he needed to collect himself. He needed to buy time. He left Alan sitting and waiting at the gate while he got ready to go. But when he took off his socks, he reopened the cut on his finger. And that's why you have blood on the bathroom floor. And under pressure to get out of there, get changed, and get going, because the limo driver's downstairs waiting, he left the socks on his bedroom floor. And in that one simple, careless act, gave us the most, possibly single most devastating proof of guilt in the case. Because on that sock we found blood that matched Nicole Brown, blood that matched the defendant, and the blue-black cotton fiber. Now, I've already talked to you about the significance of the blue-black cotton fiber. Fibers from the clothes he wore, clothes that we never found. What are the fibers that share the same microscopic characteristics as those found on the shirt of Ron Goldman, doing on his socks and on the Rockingham glove? Those are fibers picked up from the clothes he wore that night. And we never found them. He got rid of them. Now, the defendant's blood on that sock gave an RFLP match. Once again, putting him within 1 in 57 billion people. You'd have to go through 57 billion people to find blood type like the defendant's, as we found on that sock. So that's his blood on the sock. That's an identification. But that's not all. We found Nicole's blood as well. Now on this, on sock B, we have actually 2 stains for Nicole. Sock A, we have 1 stain. Now there's something interesting about these sock stains that perhaps was not made clear during the testimony. I want to bring it out now because it is very important to this notion of planting. Gary Sims testified, and when he did, he told you about the fine spatter that he found above, on sock A, that he found above the Nicole Brown stain on sock A. Little dots, I think he said there were like 10 of them above the Nicole Brown stain. And on sock B, he found little tiny spatter between the stains, 2 Nicole Brown stains on sock B. Little fine spatter. Kind of like the little spatters you would get when you stepped in a puddle or a pool of blood. Mr. McDonald didn't want to talk to me about those little spatters. You know why? Because that little spatter proves to you that nothing was planted here. That blood got on his sock because he was wearing it at the crime scene when he was committing the murders. Stepping in pools of blood. That's how that blood got there. And that's why you have that fine spatter. And as I've told you, now there was a smaller stain. I think there were 2 smaller stains of Nicole Brown that were only good enough for PCR testing. And there was 1 large stain that was good enough for RFLP testing. And the testimony gave us the fact that you'd have to look through 6.8 billion people to find the blood type of Nicole that was found on that sock. And of course, once again, that's identity. We have proven it's hers and only hers on this planet that was on that sock. All right. So with all of this blood evidence, what we have done, and fiber and hair, look at all we've traced, look at all we've proven. We have linked the defendant to the crime scene. We have linked the defendant to the victims. We have linked the defendant and the victims to his car. And that link has reached from Bundy into his bedroom at Rockingham. They are all interwoven by time, by space, by occurrence, by science. All linked. Now let's turn to the murders themselves. And in this section, I'd like to talk to you about the manner of killing. All right, in this section, I'm going to talk to you, I'm not going to start this way, but ultimately I'm going to talk to you about the law of homicide. What the people are required to prove in terms of proving that a murder occurred, what's a first degree and what's a second degree murder. Before I do that, I'm going to address some preliminary questions that, these are not questions the law requires us to answer, frankly. These are just kind of questions that you have. The things that you might want to debate in the jury room. I'd like to give you some ideas about these questions and ponder them with you for a little bit. But let me preface my remarks by saying that this has nothing to do with the elements of the crime that we are required to prove. In terms of our requirements of proof as to who did it and what they did, this has nothing to do with those. Just so you know. Because this is a matter of, as I told you in the jigsaw puzzle, this is the piece of sky. But it's interesting, and it might be something that you're interested in. So in that light, I'm going to talk a little bit about it. First of all, how could one person do this without the victims being able to scream or escape? How long did this take to accomplish? What about these murders leads us to believe that it was committed by only one person? Okay, I'll start with the last question first. First of all, if someone else was involved, that certainly does not mean that the defendant didn't do it. It just means that he didn't get anyone to help, that he got somebody else to help him. It doesn't necessarily mean he didn't do it, though. I'm not saying that he did. I'm not saying that there was a second person there. I'm just saying that that alone doesn't mean anything. But secondly, first of all, if someone else was involved on a purely basic level of observation, look at the nature of the wounds inflicted to each victim. And I don't mean look physically, because I'm not going to show them to you. But I mean, you can probably remember. The nature of these wounds, you know, as I watched the testimony, I thought, only one person could have done this because they killed the same way. The stab wounds to the back of the head, the coup de grace slash to the neck, the targeting of the neck that way. The style of killing is the same. That's just a layperson's observation, but it's kind of a practical, common sense thing. The murders look the same. You also heard a great deal of testimony concerning the murder weapon, whether it was single or double-edged, you remember that? And whether all the wounds could have been inflicted by a single-edged knife. This is also information that goes to the determination as to whether or not you have one or two killers, although I must say, two killers could have two single-edged knives, because you can't tell I don't think you can, or there was no testimony indicating whether you could match a particular knife to a knife wound. Dr. Lakshmanan testified in this regard that all of the major wounds were inflicted by a single-edged knife. He indicated to you also that there were certain other wounds, lesser wounds, in which he couldn't tell whether it was made by a single or a double-edged knife. But it would seem to make sense that if all of the major wounds are made with a single-edged knife, why would you come in there then with a double-edged knife just to do the little ones? So it just kind of makes sense that a single-edged knife was used. But beyond that, scientifically, I think we had Doug Diedrich testify that he examined the damage in Ron Goldman's shirt, and he determined that, and a shirt, of course, is less elastic than, and less messy, if you will, than flesh. And he was able to see the damage in the shirt and see that it was the knife, that the cuts in the shirt were made with a single-edged, very sharp knife, which tends to support and corroborate what Dr. Lakshmanan said. So the upshot of all that testimony is that to the extent that anything can be said based on what the wounds permit in a description of the murder weapon, it would appear to be a single-edged knife. Another indication that the murders were committed by one person comes from the blood evidence. And this is one of the few areas where there was really no dispute as to the accuracy or the reliability of the result. And here's a result we haven't yet talked about. People's 100. All right, you see that blood drop on the bottom of the boot, ladies and gentlemen? It was, that's the sole of Ron Goldman's boot. That's a photograph taken at the scene at Bundy after the coroner arrived, because you can see he's lying on that sheet. All right, now that blood drop was tested, and it was a high amount of DNA. It was a high amount of DNA because, as you can see, it was dripped on a part of the boot that doesn't look that dirty, and it obviously dried on that boot. So the DNA did not degrade as badly as it did on the concrete. Again, that's a non-absorbent surface. It's plastic, so it was preserved better. Now, what the result of that drop was a mixture of the blood of Ron and Nicole. Now, what does that blood drop mean? First of all, obviously, that blood drop, and I think Henry Lee even testified to this, was dripped on the sole and Ron Goldman was already down when it was dripped on the sole. How could it have dripped on the sole of the boot in that manner? Well, it had to have come from the murder weapon, from a knife. Those drops are dripped on, cast-off drops from the murder weapon, from the knife. And that means that Ron had already been cut badly enough to leave a quantity of blood on that knife, and it also means that Nicole had also been cut badly enough to leave a quantity of blood on that same knife. Because unless one knife has the mixture of blood of both victims on it, how can you get one blood drop from both victims? See what I mean? The blood of Ron and Nicole mixed on the knife, it dripped onto the boot, and that's why you get a blood drop with the mixture of their blood. And that shows you one murder weapon. Now, in addition to all of that, add the fact that you have virtually no evidence of the presence of a second killer. I mean, there should be something left. But there was really virtually nothing. Now, Dr. Lee tried to tell us about a second set of shoe prints, as you recall, but I think Mr. Boziak made it very clear what that was all about. The only real shoe prints found that did not match the Bruno Magli was that one shoe print that he saw on June the 25th. After police officers had walked through the crime scene, after it was broken down, you recall those photographs, 2 weeks after the crime, after cameramen had been on the walkway. I mean, what does that one shoe print mean? It means nothing, and it certainly has nothing to do with the murders. Now, what about the hair and fiber? Does that tell us anything in terms of whether or not it was one or two people that committed the murder? Now, as I've already mentioned, with respect to the hair and fiber, Mr. Diedrich testified to hairs, fragments of treated hairs that were not consistent with the defendants inside the knit cap or on the knit cap. He also testified, though, that he did not know how long those hairs had been on the knit cap, and they could be there for a very long time. But other than that, there was really no hair and fiber evidence that could be directly connected to the murders that was associated with anyone but the defendant. And by that, I mean hair or fiber on the victims or on the objects found at the crime scene that were directly and obviously involved in the murders, such as the glove, the knit cap. Dr. Lee testified to stray fibers and hairs that were in the dirt or that were on the envelope that was lying in the dirt. But stuff lying around in dirt could have been there for weeks, could have been there for months. And as I told you before, if we had found hair consistent with the defendants in the dirt there, I wouldn't be standing here and talking to you about that stuff, because so what? Show me something that is directly connected to the murders. And there was nothing. Nothing. And you know that if there was somebody else there, they had to leave something of themselves there. This was a struggle. Things happened there. Fur was flying there, as you can see. Now, while I'm talking about hair and fiber, there's one more piece of evidence that tells you that the defendant acted alone. And that is this. You recall that Mr. Diedrich testified that he found Mr. Diedrich said he found hairs consistent with Nicole Brown's on the shirt of Ron Goldman. And we know from all of the evidence that's Nicole's hair on his shirt. Think about how that happens. If the killer kills Nicole or attacks Nicole in the initial attack, and I'll get back to that later, and he touches her hair, touches her head, he gets her hairs on him, goes over to attack Ron, those hairs will be transferred. And Mr. Diedrich talked to you about how transfers occur. Logically, her hairs would get on Ron's shirt if the person who attacked Nicole then went over to Ron. There would be no reason for the transfer to Ron's shirt of Nicole's hair if two people were involved in these murders. Logically speaking, two people are involved, one takes on Ron, one takes on Nicole, but you don't have one person attacking Nicole and moving over to attack Ron if two people are there. No one wants to take their time committing murder As a matter of common sense, you're going to get in and you're going to get out. And if you've got two people available to do it, one's going to take one and one's going to take the other. And you're not going to have that kind of movement of hair from Nicole to Ron. So it's very clear. The crime scene really makes it very clear that there's evidence of only one killer, and all of that evidence establishes that that is the defendant. Next question, how long could it have taken? On this subject, there really is some agreement. There is agreement that all of these wounds could have been inflicted very, very quickly. Even Dr. Botten didn't disagree with that. Dr. Lakshmanan said it could have been just a few minutes. Now, when you realize, you look at this crime scene, look at what you have, look at where you have it. It is apparent from the evidence at the crime scene that Ronald Goldman was taken by surprise. And I'll get to Nicole in a minute, because there's evidence with respect to her too. But first let's take Ronald Goldman, because that's the one who struggled. You see, do we have that picture? Thank you. Okay, this is 43E, Your Honor. All right, you see the envelope? And it's just inside the gate. Now you remember, because you were there, how small that area is, in that caged area at Bundy. It's very, very, very tight. And that envelope is virtually with one step in the gate. It's dropped. And we have blood drippings on the envelope that indicate that it was dropped and then Ron bled, dripping onto that envelope. That indicates surprise. I'm going to show you in a moment where the keys were found as well. He dropped his keys also. Now I know a lot of suggestions were made here about how you can use keys as a weapon. I don't see how that really makes any sense, frankly. How do you use keys against a 6-inch sharp knife? And how do you see any evidence there that he even had them in his hands long enough to think about that? Those keys were dropped, and they were dropped right inside the gate. And I'll show you the photograph of where they were found. Cut the feet anyway. Okay. People's 56C. See the keys right by the gate? Now those are a little bit, if this is the gate, right here, if you step inside, it's a little bit down to my right as I'm gesturing. But again, they're right inside the gate. They're right inside. Dropped. Ron is taken by surprise. Now Dr. Lee tried to say that the struggle with Ron was not a short struggle. What does that mean? What does that mean? More than a minute? More than 5? The fact that Ron struggled is clear. But what is also obvious is that someone who gets stabbed and is flailing about can get blood all over the place as he's struggling to back away from his attacker. And that happens very quickly. I mean, you can imagine in your mind's eye somebody just flailing about, trying to get away from their attacker. A big person with a knife in a very, very dark area, very confined space. He hasn't very far to go, ladies and gentlemen. He's got only a few feet to move. And he's backed into a corner like that. Where's he going to go? He flails backwards, trying to avoid his attacker. A number of the contacts that you see, the bloody contacts on the fence, are made at once as he's flailing. And that's what you see on that fence. You see a young man bleeding, backing and falling, vainly trying to get away from the defendant, who has him cornered in a cage and is coming at him with a very long knife. Now I'm going to talk in a little more detail about how one person could do it. How? Dr. Lakshmanan spoke of the fact that Nicole suffered only two defensive wounds. One to the back of her left hand. I think it was one to the right of her palm. She struggled very little. As Dr. Lakshmanan told you, she was rapidly, that's what he said, rapidly incapacitated. She was disabled very quickly. There were stab wounds to the back of her head that indicated movement, perhaps as she tried to run. stabbing her in the back of the head. An abrasion to the right eyebrow indicates that she was pushed or fell into a hard surface, such as the wall or the stairs. She was stabbed in the left side of the neck 4 times. There was some movement shown on her part with respect to at least one of those stab wounds in the left side of her neck, which indicates there was still some effort at resistance. And now, most importantly, Dr. Lakshmanan found evidence of a scalp and brain contusion caused by a blow to the head done by either a fist or the base of a knife. A contusion that was likely to cause unconsciousness, which in fact we know it did, because when the defendant cut Nicole's throat for the last time, there was no indication of any movement on her part. It was a clean cut. That final coup de grace had smooth margins that indicated no resistance on her part. And there's a little bit more evidence of that I'll talk about later. But what's very important about these early wounds to the head and neck is that Dr. Lakshmanan told you there was evidence of bleeding in that brain contusion that showed that she lived after the infliction of those wounds for at least a minute and maybe more. Likely in an unconscious state, certainly disabled. At least a minute, maybe more, before the final throat cut was delivered. Please cut the feed, Your Honor. Now look at the upper step, ladies and gentlemen. You can see that she bled out on that step above her for a while before she came to the final spot at the foot of the stairs. And Dr. Lakshmanan testified that Nicole was unconscious when the final throat cut was administered and she was put down at the base of those stairs. If she lived for at least a minute, if not more, after she was hit on the head and struck unconscious, before her throat was slashed for the last time, and she was up on that upper step where you see the first pool of blood, what was the defendant doing during that minute or more as she was laying unconscious or incapacitated on that upper step bleeding? What was he doing before he came back to administer the final coup de grace? With Nicole disabled, the defendant had ample opportunity to deal with an unsuspecting, unarmed Ronald Goldman who had just come to do a favor for a friend. And I remind you of the testimony of Dr. Lakshmanan, in which he described the very narrow and confined space, the cage in which the defendant cornered him. A cage that left Ron nowhere to run and nowhere to hide, literally. The defendant had all the advantage, no matter what Dr. Huizinga says. He talked about Tarzan's grandfather. He's built like Tarzan. He is built powerfully. And even Dr. Huizinga said, admitted, that whatever the defendant's disabilities may be, they did not prevent him from performing the actions necessary to commit these murders. And the defendant had the advantage. He had the advantage of size. Ron Goldman was only 5'9", I think 175 pounds. Nicole Brown, 5'5", 125 pounds. The defendant, 6'2", 210 pounds. He also had the advantage of the knife. He was the only one armed in this combat. He was the only one. And he had the advantage of surprise. He knew what he was going to do, but they didn't. And don't forget, too, the adrenaline factor. That's real important. That's important. And Dr. Huizinga talked about that, because adrenaline pumps you up. And even Dr. Huizinga talked about how football players get pumped up. And you know they have to. They've got to go running through these huge men. I've never seen men that size on the football field. You've got to be able to knock them down, run through them, and you've got to get pumped. You've got to have a killer instinct to do that. And that's what the defendant did. And that's what he did that night. And the defense can talk all they want, about this new rare form of arthritis the defendant supposedly has that allows him to swing a golf club, lift a heavy set of golf clubs in that heavy golf bag. You'll have it back there in the jury room. You'll see what I mean. Lifted it not once but a few times that night, and carry heavy suitcases. That curious form of arthritis that somehow prevents him only from doing the movements required to stab and murder these people. But that's not what Dr. Huizinga, his witness, said. He could do it. He could do it. Now let's talk about the attack of Ron. Ron was attacked with the defendant behind him. That much is clear. The wounds inflicted to the neck, those control wounds, and I'll talk a little bit more about that, and some of the other stab wounds. And Ron struggles. Unlike Nicole, he's not so easily put down. He struggles, and he grabs. The defendant, who's holding him from around the neck with his left hand, and holding the knife in his right, Ron is struggling, and he's grabbing at anything he can, and he's grabbing at the hand that's holding him, and that's how the glove comes off. And by the way, that's why the right glove doesn't come off, because the right glove, the right hand, is holding the knife, holding the glove in place. But from that point forward, after the defendant first attacked him, Ron's death was not a matter of if, it was just a matter of when. And Ron was totally on the defensive from the start, trying to ward off the knife and to back away. And in the process, hitting the fence, the trees, and everything around him in a desperate effort to survive. And all of this had to have happened very quickly. And I say this as a matter of common sense. It didn't take Ron Goldman and Nicole Brown more than a few minutes to be overcome and slashed to death. And that's not really surprising. Think about it. A boxing match, each round is what, 3 minutes? And this is with men that are both prepared, ready to do battle, in good condition, who are not taken by surprise, who are prepared to do battle. And we know knockouts occur in the very first round. They certainly happen within a minute. And that's with trained professionals. Same thing with martial arts matches. Very quick. All right, next question. Why did he leave the cap and glove? This one's probably very easy. It was late. He had to catch a flight. This took longer than expected. Ron Goldman was not expected at this scene. He was not supposed to be there. But it is only because of him, because of the struggle that he put up, that we have the cap, we have the glove, and we have all this evidence. Ron's shirt, the blood. Because of the struggle with Ron, we have all of this evidence. But I'm not saying that the defendant was not aware as he was leaving the scene that he knew he had lost evidence, because he was. There was evidence given to you by Mr. Boziak, who testified that he saw hesitation shoe prints down the Bundy walk, that he saw evidence that the defendant walked down the walkway, stepped back against the north wall, and stepped out as though to look back at the crime scene. And what that shows you is evidence that I've lost my cap, I've lost a glove, but he's thinking about going back but doesn't dare. Time is running out. He might be seen by someone. The longer he remains, the more likely to be detected. And probably the dog howling already. And so he has to leave. Don't forget, too, that the glove and the cap are in complete darkness underneath that plant, in that very dark area in the front of Nicole's condominium. Now, I know that I have not explained every move that was made by the defendant, which blow came first, which one came last, and which one came in the middle. The law doesn't require us to do so, and of course there's a simple reason for that. Because short of a videotape, we very rarely know exactly how any crime occurred. People who commit murder obviously try not to do that in public and where everyone can see them. Their victims can't talk, and they can't tell us what happened. We have to look to the physical evidence, and we have to use our common sense and our reason to make reasonable inferences to determine what happened to the best of our ability. And even if we had a videotape, ladies and gentlemen, it wouldn't show you everything. What happens before the tape starts? What happens after the tape ends? And what if, and of course a camera only picks up what's in its lens. So if you saw, for example, a videotape of this case that had Nicole, that was able to focus on Nicole, but not pick up Ron, and you saw the defendant killing Nicole and slashing her throat, and then he stepped out of range to attack Ron, would you thereby conclude that he didn't kill Ron? No, of course not. Of course not. So the law does not require that we prove how a murder was committed, simply because, in that case, we'd have very, very few convictions for murder. The law requires that we prove that a murder was committed, who committed it, and what degree of murder it was. So the order of wounds makes very little difference. It doesn't answer any of those questions that we're required to answer, and that's what we're here to determine, is those questions that the law asks us to prove. But there is one aspect of the nature of these murders that is a very telling point when you think about who did it. When you look at these pictures, ladies and gentlemen, you see rage, you see fury, you see overkill. This is not the mark of a professional killer. These are not efficient murders. These are murders that are really slaughters, that are personal. And in that respect, they reveal a great deal about who did them. No stranger, no Colombian drug dealer. A man who was involved with his intended victim. One who wanted to control her and failed. And in failing, found the one way to keep her under control where she could never slip out of it again. And that man is this defendant. I have one more to go, so...
All right, ladies and gentlemen, we're going to take our mid or late afternoon recess at this time. Please remember all my admonitions to you, and we'll stand in recess until 6 o'clock. All right? Thank you.
Good evening, ladies and gentlemen. We're really hanging out together today, aren't we? I hope you all had a real good dinner. I'm going to conclude my remarks for you at this point in about, I don't want to say exactly what time, lawyers are always wrong, but I really think it'll be about half an hour. Okay, and I'm going to talk about the law of premeditation, and that means first and second degree murder. Let me tell you briefly what I forgot to tell you in the very beginning. In all criminal cases, because the people have the burden of proof, I argue to you first, and Mr. Darden will then argue to you. That's the prosecution. Then the defense will argue. Then, because we have the burden of proof, we get to argue again. We get the last word, so to speak. But it's fair because it's our burden. Okay, so you're going to hear from me again. I'm making now to you the bulk of my remarks. I hope and pray not to be taking as much of your time when I stand up to speak to you again at the conclusion of the case. So I just wanted to let you know that that's the order of things. That's the way it goes in criminal trials. All right. Do we have motive? Now, under this category would fall the subject matter that Mr. Darden is going to address, so I'm not going to discuss it with you other than to mention that the past episodes of domestic violence between the defendant and Nicole, that evidence is evidence of motive. I'm not going to say any more about that because Mr. Darden will address it. The next category is planning activity. What did the defendant do that shows us that he was planning to commit murder? Okay, now I'm going to come back to those questions I asked you to bear in mind early in the argument. Remember when I asked you, think about this? Why did the defendant go out and ask Cato for fives for the sky cap to break the hundreds that he had if he was already going to go out and eat? Remember, I asked you that in the beginning of my argument. The significance of that, of asking Cato for the fives, to asking him for change, when he already knew he was going to go out and get something to eat and could obviously get the change at that point. He obviously didn't need Cato to give him those fives, so what was the point? And even when he went out with Cato and he got the change back, he didn't keep it. So getting change from Cato was not the point. And none of his conduct is consistent with what he's telling Cato. None of it makes sense unless you look behind the words. What was he doing? What he was doing was he was setting up an alibi with Cato. He's going out to see Cato so that Cato can say that he saw him. Then Cato can later say, I saw the defendant. I saw him at 10 after 9. He told me where he was going. He said he was going to get something to eat. So if it is discovered that his whereabouts are unknown during the time of the murder, he at least has someone to say, well, wait a minute. He told me. He has a non-criminal explanation for where he was. So he comes up with a pretext of needing change for the sky cap. And it's a good way to remind Cato that he's going to be out of town, too. He'll have Cato remember that alibi also. I need change for the sky cap. Unfortunately, Cato stepped in his way. Cato invited himself along. And the defendant would have been hard-pressed to refuse. Because think about that. If Cato's going to be his alibi to tell anyone who later asks that I saw the defendant at thus and such a time, and then he said he was just going to go out to get something to eat, and then he says, but I tried to invite myself along, but he wouldn't let me go with him, then you have further evidence of consciousness of guilt. Then it's going to look suspicious. Why did you let him go with him? What's the big deal? I mean, he lets him live there. So the defendant agrees. Take Cato with him. This unexpected development, however, eats up time for him, time that he could have had out thinking about what to do. Something that he was getting ready to do, getting ready to commit the murders. So instead of going to a real restaurant, which he had the time to do, at 10 after 9, the limo isn't going to get there till 10:45. Even if you assume there's some packing to be done for a one-day trip, how long does that take? They could have gone to a restaurant. But no, they didn't. They went to McDonald's and they went to a drive-thru, the quickest way you can possibly think of to get some food. And he went there in the Bentley. Now think about that. Why take the Bentley? Why not take the Bronco if all you're going to do is go to McDonald's? Unless there's something in the Bronco you don't want Cato to see. The knit cap, the knife, the gloves. If Cato sees those on the night that he intends to commit those murders, before he has committed them, and the police get to him and say, what did you see? Where were you? I mean, what did happen? What happened in this case? He's going to say, that knit cap. I know where I saw that. These things have to pass through his mind. Now, he's got these things in the Bronco. He doesn't want Cato sitting in that Bronco with him. So they took the Bentley. Now, once they got their food at McDonald's, the defendant eats his in the car all the way home. Why do that? You got plenty of time to take it home, eat it in your house, relax, live a little. It doesn't have to be rushed like that. But he eats it quickly. Why? Because now his time has been eaten up by Cato coming along, time he doesn't have. Cato saves his. And it was interesting because he complained about being tired. It was about, 20 after 9, 25 after 9? They were in the car on the way back, I think it was. And he complained about being tired, and Cato said, well, why don't you take a nap? He said, well, I've got no time. When I heard that, got no time? The limo, it's 9:25, the limo doesn't come till 10:45. You got time to lay down. Unless you're planning on doing something else. But what was really telling was after they got back, when they both got out of the car and Cato walked straight for the house and the defendant stood there by the Bentley not moving, watching Cato. Why do that? Why do you stand there and wait? Why not go in the house? Why not get back in your Bentley or get in the Bronco? Why do you wait for Cato to get out of sight? Unless you don't want him to see where you're going. Unless you have it in mind that you're not going to go back in the house. You don't want to take the time to do that. And you don't want him to see you going to the Bronco. Now there's much more evidence of planning. Planning that you see at the crime scene itself. And in that I mean the defendant wore dark clothing. The dark blue black cotton sweatsuit that Cato described, perfect in the nighttime if you don't want to be seen. the dark blue, black cotton fibers that were found on Ron Goldman, the socks, the Rockingham glove, the fibers of the clothing he wore. The watch cap and the gloves. It was June the 12th, the summer night. Why do you need these cashmere-lined gloves and a watch cap on a summer night? Unless you're going to commit a crime. Unless you're planning, unless you're preparing to commit a crime. Gloves are easy. Why wear the gloves? Fingerprints. You don't want to leave fingerprints. And he didn't. You heard from the print people, he didn't. Watch cap. A partial disguise. If he has to walk around the house, if he's going to be standing at the front gate, he doesn't want someone glancing to make the immediate connection. He doesn't want someone to see exactly who it is right away. Now, he doesn't intend to be there but a minute. But a watch cap over that head is going to make somebody, that doesn't look like something that he would wear, and it throws someone off. Now, those items alone show clear evidence of planning activity, planning for a murder, preparation. But there's more. There's also timing. And by that, I mean, we know that the children were asleep at the time these murders were committed. We know that from the evidence. But who else would know when the children were going to be in bed? Who else would know when they would be safely out of the way? Who else would know when Nicole would be home alone with the children? Who else would know the perfect time to attack and get Nicole without the children being in the way? The defendant. And that not only shows premeditation, it also shows identity. Who did it? Now, there's one more thing that shows evidence of premeditation and deliberation, and that's the knife. In the inventory tape that you have in evidence, the defendant's closet is shown. And it's shown that he had in that closet a gun. He had a gun, but he chose a knife. And this choice is evidence of planning. A gun makes noise. A knife doesn't. Particularly if your intended victim is half your size. A gun is registered. It can be traced. And bullets can be matched to guns. And even if you get rid of the gun, the type of bullet can be determined. It can be determined to have come from the type of gun you used to have. So if you get rid of the gun, it's looking even worse, almost, than if they catch you in possession of it. Suddenly don't have the gun after your wife was shot to death, and a bullet that could have come from that gun. But not a knife. A knife can't be identified to the exclusion of all other knives in making this wound or that wound. You can't match a knife to a murder. A knife isn't registered. All of these things make a knife a better weapon of choice than a gun. But maybe more than all of that, a knife is up close and personal. And that's the kind of murders these are, ladies and gentlemen. These murders are up close and personal. If your desire is to vent your rage on someone, a gun is far too sterile. It's far too removed. But a knife, it's lethal, but it affords the opportunity for the expression of violence, power, and control at very close range. The choice of a knife is evidence of planning, and it too is also evidence that the defendant is the murderer. Now, there's more evidence of premeditation and deliberation in the nature of the wounds themselves. Let's start with Nicole. As I previously discussed, Nicole was incapacitated very quickly. She had little, if anything, in the way of defensive wounds to her hands, and she had no opportunity to defend herself. Likewise, the 4 wounds in close proximity on the left side of her neck, very close to one another, they indicated very little resistance, and they suggested that she was controlled or otherwise incapable of moving away to avoid being stabbed. And the gaping neck wound, the final coup de grace that nearly decapitated her, that is classic evidence of a cold, calculated, premeditated murder. Now recall that this was a wound that was 3.5 inches deep, severed both carotid arteries and both jugular veins. This wound was so deep that the tip of the knife took a 1/4-inch gouge out of her vertebrae. As you recall, and I've discussed it before, when this wound was inflicted, Nicole was incapacitated and helpless. There was no resistance indicated in the wound. The edges of the wound were smooth. And I told you there was something else that indicated she was unconscious, and that is this. The evidence of her knuckles, unbloodied in an area where blood had already pooled around her, showed that she was incapable of raising her hand to protect herself, incapable of raising her hand to try and ward off the knife or the hand that held the knife. No, the knuckles stayed in contact with the pavement and didn't get the blood on them that they would have gotten had she been able to raise a hand to do something to protect herself. And it's further evidence of her unconsciousness at the time that that final slash was inflicted. Now you remember, as I indicated to you earlier, the testimony indicated that the bleeding into the contusion in her brain showed that she lived for a minute or more before that final throat wound was administered to her. Now that final gaping wound in her neck was inflicted upon an unconscious victim, or at the very least incapacitated. It's clear evidence of a cold and calculated decision to kill. When a victim is already incapacitated and the defendant goes back to her, pulling back her head, she's lying there basically unconscious. He pulls back her head and he slashes the throat to such a degree that she's nearly decapitated. That was a cold and calculated decision to kill, to make sure she was dead. And it allows for no other reasonable inference. Now, Ronald Goldman. Now, once again, a very significant point with respect to Ronald Goldman. As with Nicole, the neck is the target. Once again. And we know that from the neck wounds on Ron described by Dr. Lakshmanan. Why the neck? Why is the neck the target? Because it's a sure kill. It's something we've all heard about. Go for the jugular. You go for the jugular because you cut it, you slice that neck, that person's dead. That's a sure bet. That's a sure thing. And the fact that the neck is the target for both victims indicates to you also a cold and calculated decision to kill. That is the epitome of a premeditated murder. Now let me point out, with respect to Ron, you have those 2 wounds. You recall those 2 lines across the neck, almost parallel to each other, with very little bleeding in them, that Dr. Lakshmanan indicated were inflicted early on in the struggle. Their evidence, and the reason they're important, is that they're evidence that the defendant controlled Ronald Goldman, controlled him to the point that he could hold him and draw the knife across the neck in lines that were nearly parallel to each other, holding Ron from behind him, left arm around him, with the right hand drawing the knife. And Ron struggled to break free of that control. And because he struggled and because he put off the fight, it took the defendant a little longer to incapacitate him than it did Nicole. And you've heard the cross-examination, you've heard the defense attempt to say that Ron Goldman fought with his attacker. Ron struggled, but it was not a struggle with the defendant. It was a struggle to save his own life. It was a struggle to escape. The defense wants you to believe that Ron fought, that he punched the defendant. This was not a fight. and the reason we know this was not a fight was that Ron's palms are cut. For your palms to get cut, your hands have to be open. If your hands are in a fist, you're not going to get your palms cut. It's just as simple as that. And Ron's palms were cut because his hands were up as he was trying to ward off the knife, trying to defend himself.
Okay, thank you so much, Paul. We are going into the courtroom. Mr. Darden will resume his portion of the closing argument.
And Mr. Darden, are you prepared to continue on with your argument, sir?
Yes, I am, Your Honor. Thank you.
Right.
Good morning, sir. Good morning, ladies and gentlemen. Good morning. I hope everybody...
Just briefly show that to counsel.
If you can. I hope everybody had a good sleep last night. It was a long day yesterday. And I thank you. Let me thank you in advance for hearing me again this morning. I don't expect to take up the entire morning. In fact, with any luck, I won't take up more than half of it. But we'll have to see. Well, you recall where we left off yesterday. I was telling you about this defendant's relationship, this man's relationship with Nicole Brown. And I told you that it was a simmering relationship. You know, it was a slow burn. It was a slow burn. And I described for you and discussed with you some of the testimony that you heard in this case, testimony you heard from witnesses about their relationship. And we talked about the 1985 incident involving the baseball bat and the Mercedes-Benz. We talked about the 1989 incident and the fact that the police have been there 8 times before. Both the defendant here and Nicole Brown both admitted that, so I guess it's true, right? We talked about the incident at the Red Onion when the defendant grabbed Nicole by the crotch and in front of a bar full of strangers and humiliated her. We talked about that. We talked about his admission to Ship, about his jealousy after the 1989 incident. We never talked about the testimony we heard from Denise Brown. You remember the testimony from Denise Brown when she talked about some of the really, really nasty things he would say to Nicole? As you may recall, Denise Brown, Nicole's sister, testified that during the time that she was pregnant, the defendant would call her names. Do you recall that testimony? He'd call her a fat pig. And he would call her a fat pig in front of other people. Now, I don't know what you should extract from that. I mean, have you ever heard of such a thing? I don't know. I would suggest, however, that is some indication of how he really felt about her. You know, sometimes you get in a relationship, people get in a relationship, you know, and you have one half of the relationship who's dominant, and you have another half who's somewhat passive, and the dominant half dominates the other half. And what effect do you suppose this would have on Nicole? That is, being called a fat pig by her husband while she's pregnant. What effect would that have on her self-esteem? Because you're probably wondering, well, hey, if he did all of these things to her, if he said all of these things to her, why did she stay? Well, there's this old song, and the words used to go I think it was the Dramatics. I can't really recall. But there was a couple of lines in the song where they said, the strong give up and move on, and the weak give up and stay. You know, if you badger a person long enough, if you beat them down long enough, if you wear them down long enough, pretty soon you strip them of their dignity, their self-esteem, and they are weak. And they are submissive. And they can't go. They can't stay. And you know how that is. Everybody knows how that is. We've all been in bad relationships before. You have friends. You see them in these bad relationships. Why? Why do they stay? Why do they stay? Usually they feel they don't have a choice. They don't know that they have a choice. They forgot that they had a choice. In their minds, they have no choice. She's a fat pig. But we talked about that yesterday, and we talked about justice, and we talked about what the real issue in this case was about, and I pointed the defendant out to you, and I told you he killed her, and you've heard the evidence in this case. He killed Ron Goldman. O.J. Simpson's a murderer. That's what the evidence indicates. That is what the evidence indicates. That is what the evidence shows. It shows that he's not just a murderer, but he's a double murderer. And that's unfortunate. It's unfortunate that I have to stand here and tell you this, because I'd rather be somewhere else. I'm sure you'd rather be somewhere else. Who wants to really have to confront and deal with these issues? But we have to, because we have a duty. Marcia and I have a duty, and you have a duty as well. Your duty is to look at all the evidence, to be fair, be conscientious, be objective. And your duty is to look at all the evidence, the totality of circumstances, everything. We don't want you to just look at one piece. Don't just look at the prosecution's case. Look at the entire case. Look at everything. Because when you do, hey, what can you say? Except he did it. And we've proven it. And we've proven it beyond a reasonable doubt. And we talked about the safe deposit box yesterday, and we talked about the fact that Nicole knew that she was going to die, and we know that she knew that because she told the police that in 1989. And we know that she knew that because of what she saved for us, the roadmap she left for you in that safe deposit box. The letters, the photographs, the will. You recall that testimony. And as we went through the progression here, through the history of his abuse of Nicole, and by the way, not every incident here on this chart is an incident necessarily of abuse. But we wanted to lay out the history of their relationship as well. And so that's why you see things like divorce and et cetera. So we're not trying to mislead you. But we thought it was important that you know how the relationship developed over the years. And this is an unusual relationship. You have to agree. There's something wrong here. Henry Lee said there was something wrong. There's something very wrong here. This is a slow-burning, simmering relationship, and it's just like I told you yesterday, the fuse is burning. The fuse is burning, folks, and it's getting shorter, and it's getting shorter, and it's just getting shorter. But this morning, I want to take things a step further, if I may, if you'll allow me to. Let's just cut right to the chase. Imagine a defendant in his Bronco. He is full of anger, and he is full of rage, and it's nighttime. And he's driving that Bronco, and he is full of jealousy. And the fuse continues to burn. And the focus of his anger is Nicole. For some reason, in his mind, she has done something that he can't ignore, something that has set him off. He's jealous, he's raging, he's out of control, and he's in that Bronco, and he is driving as fast as he can toward Nicole's house. And it's about 10 o'clock. He is out of control, folks. He is completely out of control, and when he gets to Nicole's place, he quickly parks the Bronco and he gets out. It's 10 o'clock. He's in his Bronco. He's at Nicole's house. It's nighttime. But we're not even talking about June 12. We're not talking about June 12, 1994. We're talking about October 25, 1993. All along, I've asked you to be open-minded. To be open-minded about this man and who he is. And we have suggested to you, and I think we've proven to you, that he is not the person that you see on those TV commercials and at halftime in those football games. That is his public persona. We all have one. We all have one. We behave a certain way when we're in public, and we behave another way when we're at home. You know what they say, nobody knows what goes on behind closed doors. And the fact that we may see you and you may see us doesn't really mean that you know us, or that you know me, or you know Miss Clark or Mr. Cochran. You see us here in public. But what are we? What are we really? What are we really inside? What are we really at home? Well, we have a very, very, very nice example. Well, nice is a bad choice of words. We have a very, very poor example of who this man is, of who he is at home, of who he is in his private life. It's the private side, the other side of him. And I want you to listen to a tape of an emergency call. And you recall that I played that tape for you a long time ago, months ago, and you probably forgot about it. Up until yesterday, I hope. But I'm going to ask you to listen to that tape in just a moment. Now, you know, some people say, well, how could O.J. Simpson actually kill this woman and Ron Goldman when her kids are in the house? You know what I mean? They say, well, who would do something like that? Well, he would. Keep this in mind, if you will, if you think it's important. In 1989, when he beat her, you'll recall that when the police came and wanted to take her to Parker Center to have photographs of her injuries taken, you'll remember that she said, I don't want to go, I just want my kids, just take me back home to my kids are at home, I want to be with my kids. The night he beat her, his kids were in the house. And when you listen to this tape from October 25, 1993, after the first couple of minutes, you'll hear the defendant in the background yelling and screaming and raging. You'll hear that rage. And you'll hear Nicole on the telephone say, the kids are upstairs. The fact that the kids are in the house means nothing to this man.
911 emergency.
Can you get someone over here now to 325 Gretna Green? He's back. Please.
Okay, what does he look like?
He's O.J. Simpson. I think you know his record. Can you just send somebody over here?
Okay, what is he doing there?
He's just throw my man. Somebody over.
Wait a minute, what kind of car is he in?
He's in a white Bronco, but first of all, he broke the back door down to get in.
Okay, wait a minute, what's your name?
Nicole Simpson.
Okay, is he the sportscaster or whatever?
Yeah.
Okay, wait a minute, what's in the police? What is he doing? Is he threatening you?
He's freaking going nuts.
Okay, has he threatened you in any way, or is he just harassing you?
You're going to hear him in a minute. He's about to go in.
Okay, just stay on the line.
I don't want to stay on the line.
Just stay on the line so we can know what's going on until the police get there, okay? Okay, Nicole? Just a moment. Does he have any weapons?
I don't know.
Okay.
He went home and right back. I guess they're upstairs sleeping. I don't want anything to happen.
Okay, just a moment. Is he on drugs or anything?
No.
Okay. Just stay on the line, just in case he comes in. I need to hear what's going on, alright?
You hear him outside?
Is he yelling?
Yeah.
Okay. Has he been drinking?
No.
Okay.
One fellow unit, additional domestic violence, 325 South Gretna Greenway. The suspect has returned in a white Bronco. Monitor comments, incident 4221.
Okay, Nicole? Is he still outdoors?
He's in the backyard.
He's in the backyard?
Screaming at my roommate without me and at me.
Here. Okay. Okay, what is he saying?
Oh, something about some guy I know and hookers and keys and
Not your guys, where was that?
I started this shit before and it's all my fault. And now what am I going to do to quit it on this? And the whole thing. It's all my fault.
Is No. Okay, you don't need any paramedics or anything? Okay, you just want him to leave?
My door. He broke the whole back door in.
And then he left and he came back?
And he came and he tried to knock my upstairs door down, so he pounded it, and then he screamed and hollered, and I tried to get him out of the bedroom because the kids were sleeping in there. And then he wanted somebody's phone number, and I gave him my phone book, or I gave him Cliff's phone book down the way. I just write down the phone number that he wanted, and then he took my phone book with all my stuff in it.
Okay, so basically you guys have just been arguing? Is he inside right now? Okay, just a moment.
I think we've heard enough of that. You'll have this tape in the jury room. I'm just a messenger. And I think you get the message. And you get the message straight out of his mouth. I mean, you hear this man in the background raging. He is raging about a picture of a man he saw at Nicole's house. A picture of a man she had apparently dated how many months before? How many months did Nicole say? It was about 18 months or something like that. It's on the tape. And Nicole said on that tape as well that it always comes up. This man, that issue, always comes up. Apparently, this man and that issue is of great concern to the defendant, of so much concern that he apparently just can't get it out of his system. He can't put it behind him. He can't forget it. He can't forget it. And you hear him back there yelling and screaming at Nicole, and you hear the language and you hear the things that he's saying about her, and you hear him in the background say, I don't give a shit anymore. That's what he said. An old relationship, a past boyfriend, a boyfriend she apparently had at a time after she moved away from his home and after she filed for divorce. A year and a half. And he still hadn't gotten over it. And it's October 25 in 1993, and Nicole doesn't know it at the time. She knows he's going to kill her at some point, but she doesn't know at the time that she only has 8 months to live. Now, we offer this tape to you, as I said before, so that you would know who you're dealing with. And because you have a right to see him, the private side of him. When you listen to the 911 call, as you take it back into the jury room, listen to the part where she tries to calm him, where she's on the phone and it sounds as if he's getting closer to her because you can hear his voice more clearly and his voice is raised even higher than before. And she tries to calm him, and as she's trying to calm him, she tries to calm him by using a calm voice of her own. You get what I'm saying? I mean, she says, OJ, OJ. Now, 3 minutes before, she was in tears on the phone calling the 911 operator, but when he comes near, he's enraged. She is trying to calm him down with a calm voice. What does that mean? I mean, is that helpful to you at all? Let me suggest to you that what that means is that she's been there before. She apparently feels as if she has a way, some tactic or some approach that might help calm him down. It's Nicole's approach to her problem when the defendant becomes enraged. A calm voice. And she is scared. And you know she's scared. You can hear the fear. You can hear the terror in her voice when she calls the 911 operator. But when he gets close and when she gets to the point where she has to calm him down, she's the calm one. She's the one who is in jeopardy. But she's the one with the calm voice. 1993 was the same year that the defendant talked to Cato Kalin. Remember, Cato Kalin was living at Gretna Green with Nicole. He was living in the back in the guest house. And he talked to Cato just before Nicole moved to Bundy. You remember that conversation? You recall that testimony? This is an example of this man's control, of the control he had over Nicole, the control he exercised over her. Cato was living with her. Cato's going to be paying rent to her, to Nicole. This is money. This is income. Okay? She's divorced from this man. She is not his wife. She is not his wife. She has not been his wife since 1992. Okay? Cato lives there. She has no relationship, no intimate relationship with Cato. She has a right to have him live there in the guest house if she wants. And as she moves to Bundy, if she wants Cato to rent a room, she has that right. I mean, this is 1993. He has no right to interfere with that, but he wants to exercise control over her. He's about control. This is all about control, ladies and gentlemen. It's all about control. The beating, the humiliation, all of that. That's how you control people. You beat them down. They lose their self-esteem. You humiliate them, and pretty soon, they're like puppies. He talked to Cato, and he said to Cato that it wouldn't be a good idea if he moved to Bundy. It wouldn't be right. Remember? Well, you know, you meet people and you get involved in relationships, and he continued his relationship with Nicole, and you have to take people at face value and take them how they, you know, take it how it comes to you. You know what I'm saying? If he wanted to be with Nicole, then he should be with Nicole the way she is. And if the way she is that she needs a tenant to pay rent, to make it or whatever, that's her thing. He should just accept that, but he doesn't. He talks to Cato, and what does he do? He bribes him. He bribes him away from her. Cato was going to be paying $450 to $500 rent at Bundy. He bribes Cato away, and what does he do? How does he do it? Cato, come live with me over at Rockingham. We got the jacuzzi, the pool, your state, the tennis court. You got your own room. And what's it going to cost you? What's it going to cost Cato? Nothing. Zero. Zilch. Scratch. It's free. He's bribed Cato away from her, and she is upset about it. You heard the testimony. Nicole talked to Cato, and she begged him not to do as the defendant asked. She told Cato that he was being manipulated. This is control. But Cato told you from the witness stand that the deal was too sweet. It was a freebie, free stuff, free rent and board, free room and board. How could he turn it down? He turned his back on Nicole, and Nicole was angry about that. Nicole named her dog Cato. Think about that. Nicole named her dog Cato. I'm not suggesting to you that this man was angry and depressed and consumed with jealousy each and every moment of the day or each day that he was with Nicole. I'm not saying that. I'm sure that there were periods of calm. I'm sure that there were periods when they had a good time. I'm sure there were times and periods when things worked out great for both of them. But always beneath the surface looms this jealousy and this anger and this passion and that rage, the rage you just heard on that tape. And you know, if you're in Nicole's position and you know all about this, and you know that, hey, you know, there are certain things that can set him off, that can set that fuse to burning, that can make that fuse shorter and shorter, then you're going to tread lightly, right? You're going to try and do everything you can not to upset him. And that's control. They went back and forth in their relationship. They'd make up, then they'd break up. They'd try to get together. They had kids. That sounds natural, right? I mean, you know, there's nothing wrong with that per se. And as I understand the testimonies, I recall that they were together again in the spring of 1994. Despite all of that, despite everything that had happened up until this point, in 1994, she moves in January to Bundy, and in the spring she begins dating the defendant again. And Cato Kalin told you from the witness stand that they had some kind of commitment either to each other or she to him. I'm not sure of all the details, but you heard the testimony. And if my memory fails me, then, you know, rely on the testimony in case I'm incorrect. But they had some kind of agreement or commitment that she would date only him or wouldn't date anybody else before he left to go to New York for football season. She was supposed to date only him until August. And Cato said that that was a commitment, that they had that commitment. Well, somebody broke the commitment apparently. And May 19, as I recall, was Nicole's birthday. And for her birthday, he gave her an expensive bracelet. And on her birthday as well, as I recall, she was sick with pneumonia. Was that the testimony? She was sick. And I think someone said, it may have been Miss Arnell Simpson, that the defendant had brought her soup, taken soup over to her on her birthday because she was sick, or maybe the day after her birthday, but sometime around that time period. But for some reason, Nicole broke off their relationship. She broke off the relationship. For some reason, on May 22nd or thereabouts, Nicole got the courage, the strength to break this relationship. Now, you have to assume that when someone moves out of your house, that that's an attempt to break off a relationship. And you would think that he would get the point. When she filed for divorce, you would think that he would get the point. Then when the divorce is final, you would think that he would get the point. But they go back and forth for whatever reason. I'm not saying it's all his fault. I'm sure to some extent it's Nicole's fault also, if we can fault anybody for this. But she returns that bracelet on or about May 22, 1994. She couldn't be bought. She couldn't be controlled anymore. She had had enough. And when you look at the things that transpire after May 22, 1994, you get the sense, don't you, that he finally got the message? It's over. It's over. She can't be bought. You can give me this expensive gift if you want to. That's fine. But I'm not staying in this relationship. Take it back. And she gave it back to him. And the defense would like you to think that this was but there was no big deal to this breakup, that nobody was upset, that he wasn't upset about it. But was he? Christian Reichard testified from the witness stand for the defense, and he told you that the defendant had been depressed during the weeks leading up to the murder. He had been depressed because of his failing relationship with Nicole. He was depressed because she couldn't make up her mind as to whether or not she wanted to stay in the relationship. You recall that testimony? He was depressed about that. But it seems to me that perhaps his depression turned to anger. Do you have the IRS letter? In the days that followed, and we don't know everything that happened between them in the days that followed, but we know that at some point there was a letter that he wrote to her. We assume that he wrote it because his signature is on the bottom, and this letter has been marked as evidence, and Mr. Fairlow will get the exhibit number. The actual letter has been marked as evidence. And the letter was dated June 6. And it's signed O.J. Simpson. And in the letter, now remember, there are no hard feelings here if you believe the defense case. And this letter begins, on the advice of legal counsel and because of the change in our circumstances, I'm compelled to put you on written notice that you do not have my permission to use my address at Rockingham as your residence or mailing address for any purpose, including but not limited to information and tax returns filed with any taxing entity. Well, what is this? What does this letter mean? How is this letter helpful to you? How many times do we break up with someone and then send them a letter a few days later or 2 weeks later in legalese? And what are the changes in their circumstances that he's referring to? The change in their circumstances is that she has decided that she does not want to be with him anymore. And now he's out to hurt her. He's going to hurt her. This letter is People's 25, Your Honor.
Thank you.
Did Nicole have some kind of tax problem? Looks like it. In the last paragraph, he says, I cannot take part in any course of action by you that might be misleading to the IRS or the Franchise Tax Board. What is he suggesting to her? How should she receive this letter? And look at the carbon copy. Mr. Cochran asked someone on the witness stand if they knew that Marvin Goodfriend was his accountant, as I recall. We've heard that Leroy Taft is his lawyer. A carbon copy to his lawyer and his accountant. What's going on here? This is supposed to be an amiable breakup? No hard feelings? This is control. This is a subtle threat. If you disagree with me, fine. If the defense disagrees with me, that's fine as well. But let me tell you something. When the defense began the defense case, well, not the defense case, but when Mr. Cochran did his opening statement, he told you about a witness he intended to call. And this witness seemed to be a pretty important witness, and would seem to be, given the evidence that you've heard in this case. He told you about a woman named Dr. Lenore Walker. And he said to you at page 11783 that there's an expert in the U.S. whose name is Dr. Lenore Walker, and that she is, by all accounts, the #1 expert in America on the field of domestic violence. And he said that she has been called by some the mother of the battered women syndrome. He went on to tell you that she was a psychologist. And she had interviewed and tested the defendant. The things that I am saying to you and discussing with you today, the testimony that you heard from the witness about the domestic violence, the beating, the abuse, the intimidation, the threats, the stalking. Did they call one witness to rebut any of that testimony? They called 58 witnesses. How many came to address the 1989 incident, or the October 23, 1993 incident that you heard on the tape? Or why didn't they call Dr. Walker? Who could have put this all in perspective for you if what the witnesses said in this case aren't true? I mean, it wasn't true. Dr. Walker could have interpreted this letter for you. But they didn't call Dr. Walker. They wouldn't call Dr. Walker. They better not have called Dr. Walker. And Dr. Walker never stepped foot into this courtroom while you were here in the jury box. They are a group of very, very fine lawyers. They called some of the most expensive experts money could buy. But we didn't see Dr. Walker. We didn't see her explain to you why this letter is insignificant, if that's the defense position, or why this cycle of violence that led up to Nicole's murder doesn't help to establish motive from a practical sense. And there was something that he said to you on page 11793, and I want to take a moment and show it to Mr. Cochran before I read it, if I can. And at page 11793, he said to you, I'm going to tell you about the facts. And he says, so you will hear from Dr. Walker, and you will hear about the battery of tests, and I think you will find that she will say that in looking at O.J. Simpson, she tested, that in looking at O.J. Simpson, and interviewing him and looking at him, at this point she finds no evidence of antisocial personality disorder, and I think you will find that becomes very important in this case. So where is Dr. Walker to come here to testify, to take the witness stand, to sit in a blue chair and tell you that none of this is important, that everything I've told you for the last 3 hours is insignificant and unimportant? Where is she to tell you that he does not suffer from some antisocial personality disorder? She ain't here. And had she come here and expressed an opinion that this was unimportant, we could have cross-examined her. But they can't touch this. They can't touch this. This is important evidence. You have to consider it when you consider motive, when you consider the issue of identity, the identity of this man as the killer of these two people. You have to consider this on the issue of premeditation. This is important evidence. As the days proceeded on, we know that he hired an interior decorator. As I recall the testimony, Paula Barbieri, his new girlfriend, the one that he was so happy with. It's odd, but on the one hand, they say he was happy with Paula Barbieri. On the other hand, Cato said that he told him The defendant told Cato that he, the defendant, didn't know if Paula was the one. I don't know. But let me tell you something about this letter, just to go back, and this whole interior decorator situation. The fuse is burning, and it is getting short. Okay, it's getting short. He is trying to erase her presence, for instance, from his home. Okay, this is how short the fuse is getting. He's trying to erase her presence from his home. He has hired an interior decorator to redecorate the bedroom, the master bedroom, was it? And the bathroom. They're going to rip out the plumbing. The places she had been, they are going to change. They are going to erase her presence from the house. He is going to erase her presence from the house, or at least he's going to try. He is angry and he is upset. He has been rejected and he doesn't like that rejection. And he's trying to get over her. He's trying to get beyond this. And so what does he do? He gets rid of her wedding photo, their wedding picture, puts it underneath the bed. He is trying to get beyond this, but he can't get beyond this because the fuse is burning, because he is upset and angry that the relationship was terminated by her. I mean, you look at that picture, you look at them. After you're divorced and after you break up with someone, you don't usually keep the pictures out, right? I mean, you don't. But do you throw them underneath the bed? You put them in a box, or you get rid of them altogether. That's what you do. But in this case, in his case, he is trying to get over her, but he can't. He can't get over her. He can't get beyond this. On the one hand, he throws this picture underneath the bed. And on the one hand, she is out of sight, and he hopes out of mind. But on the other hand, she's just beneath the bed, where he has access to it, where he can grab it, and where he can look at it. He is beginning to obsess with her. He is becoming obsessive with her, and he is trying to replace her at the same time with Paula. His relationship with Paula supposedly blooms again all of a sudden at about this time, right after she breaks up with him. If she broke up with him on May 22nd, and by June the 6th or whatever, he and Paula are back together, and now they're ripping the plumbing out of the house. You know, people need space. You need time when you end a relationship, especially one that lasted 17 years. He is trying to replace Nicole with Paula, and he is trying to find some sense of control. But the fuse is burning. And I just wish Dr. Walker had been here to help explain this to you. I'm sure she could have done a better job of it than I have so far. And so we move on. The days pass, and that photo was People's 536, the wedding photo. And the days pass, and we begin to approach June 12th, the day of the recital. You recall that the defendant had conversations with Cato Kalin that day, and he talked about Nicole. He talked about her dress. He talked about how short it was. He talked about the relationship being over. It didn't appear, you tell me, maybe you disagree, that he and Cato Kalin had that kind of relationship, the kind of relationship where he would vent his frustrations regarding Nicole to Cato. I don't know. You saw Cato, and I don't know why anybody wanted to discuss the personal problems with Cato Kalin, but he did. And he talked about Nicole a couple of times that day to Cato Kalin. And Marcia cross-examined Cato Kalin and directly examined Cato Kalin. And they talked about those conversations. And as Marcia mentioned yesterday, Cato had a bias. And he was biased in favor of the defendant. He minimized things. That's not to say that he just outright lied about things, but he minimized things. I think he minimized the tone of the defendant's voice when he talked about Nicole. I think he minimized just how upset the defendant was when he talked about Nicole. But hey, whatever. The defendant supposedly seen Paula. It's the day of the recital. And what happened that day? Well, the fuse got shorter. I'll tell you why. Paula's new girlfriend wanted to go to the recital. The recital where Sydney was going to be performing over at the school. And they had an argument about that, for lack of a better term. They had a disagreement about that. She wanted to go. He didn't want her to go. He wanted to go alone. He told Cato that they had a disagreement about that, and she was upset. Well, why is that important? It's important because she left. It's important because Paula left. She left Rockingham. She left Los Angeles. But apparently he didn't know that. Apparently they had their disagreement about the recital. Paula got mad. Paula left town. It's pretty apparent that he didn't know that. I can't tell you how bad that disagreement was, or if there were raised voices or whatever. We don't have any of that in the testimony or in the evidence in this case. But we do know that Paula left and that he didn't know where Paula had gone. And the fuse is getting shorter, because what happened that day is this. Paula, as a woman, I guess she's asserting her womanhood. She's supposed to be his woman now. She wants to go to the recital. Why not? He won't let her. Why won't he let her? Because he still has hope for Nicole. He still has some hope. He still has some hope. He doesn't want Paula to go to the recital. He won't let Paula go to the recital. And Paula realizes why. And she packs up and she leaves. That afternoon, the defendant called Nicole. We'll get the right photo board. That afternoon he called Nicole's house. See, he's still got hope. He's got hope that, she's always come back, right? Each and every time that they've gone back and forth many, many times. They've always gotten back together. She's always come back. But she isn't coming back this time. But he still has hope. He's put in a catch-22 situation of sorts that day when he and Paula talk about her going to the recital. He has to make a choice that day. He's either going to go to the recital where Nicole is, alone, hope in hand, or he's going to choose Paula. It's either Nicole or Paula. If he takes Paula to the recital, take her out in public, take her around Nicole, take her around the Brown family, he's made a choice now, okay? It's public. Everybody knows he has made a choice. He is now with Paula. But he couldn't make that choice because he still had hope, and he still had hope for Nicole. And so he called Nicole on June 12th. He called her and talked to her at 2:18 in the afternoon. It was a 4-minute phone call. And something happened during that phone call. But let me tell you what else. That after he finished that 4-minute phone call with Nicole, he tried to call Paula. As soon as he hung up with Nicole, he tried to call Paula in the 305 area code, Florida, right here. The phone call it began at 2:18, it lasted 4 minutes. At 2:22, he's calling Florida. Something happened. I don't know what happened. Something happened. Whatever happened during that phone call, he had a need to talk to Paula thereafter or immediately thereafter. But he's calling Florida looking for Paula. But we know from the testimony and the evidence in this case already that Paula's in Las Vegas in a hotel room being paid for by Michael Bolton. He doesn't know where she is. Sounds like she got upset and stormed off and went about her business. But he can't find Paula. He's having a problem with Nicole. He's about to lose all the women, both the women in his life. And the fuse is getting shorter, folks. It's getting shorter. And the frustration is building. Okay? And the anger is building. And something has triggered his anger, because in all of this, this is a tension. This entire relationship over a 10-year period is filled with tension because of the doors being kicked in and the punches and the slaps and the intimidation and the control and all of that. I mean, this is a very, very tense relationship, and things are about to explode because he has that conversation with her. He tries to call Paula. He can't find Paula. And by the time he gets to that recital that afternoon, around 5 o'clock, he is fit to be tied. He is angry. You heard the testimony of Candace Garvey, Steve Garvey's wife. She was also at the recital. She knows the defendant. She'd known him for a long time. He came into the recital. She and Steve spoke to him. He said, "Hello. How are you? How are you doing?" And what was her testimony? What was his response? There was no response immediately. Do you recall her testimony? He had a blank stare on his face. He was distracted. She told you that it was as if he looked right through her, as if he didn't recognize that she was there. And she told you that his demeanor that afternoon in the recital frightened her. And she told you that he was angry. And Denise Brown testified as well about that recital. And they told you that he was angry and he didn't look to be or act like the O.J. Simpson they had come to know. Candace Garvey said that he was distant, that his anger was simmering, that he had this look of simmering anger. He was in a slow burn and the fuse was getting shorter. Something set him off, and perhaps what set him off was this 4-minute phone call at 2 in the afternoon. Perhaps his inability to find Paula that afternoon set him off. Okay, now the fuse is really burning. Now the fuse is getting shorter. And there's going to be an explosion, folks. There's going to be an explosion. He arrives at the recital. He sees Candace Garvey, literally ignores her. He's angry. He takes a seat in the auditorium. He sees the Brown family seated in the auditorium. Okay. Judith Brown and Lou Brown, Nicole's parents, and her sisters. Nicole is seated with them or near them. He goes over to the Brown family and he greets everybody in the family, every one of them. He greets everybody but Nicole. He doesn't address Nicole. This is a family event, right? His daughter, Nicole's daughter, at the recital dancing, but he doesn't address her because he is angry. He is consumed with anger, and the fuse is getting shorter. He doesn't appear like the O.J. that they knew, the man that they knew. Candace Garvey is frightened by his demeanor, and what does he do? He takes a seat behind the Brown family. And there are no seats near the Brown family, so nothing wrong with that. Nothing wrong with the fact that he takes a seat behind the Brown family. But as Denise Brown told you on the witness stand, after a few minutes, he just abruptly got up and moved. He got up, took a chair, and in the dark, in this dark auditorium, because the program was going on, he takes that chair and he moves it into the corner and he sits in the corner of the auditorium. Denise Brown told you that she could not understand. She did not understand why he did that. She told you on the witness stand that she didn't say anything to offend him. Nobody said anything to offend him. Why is he so angry? Who is he angry at? Well, common sense would tell us that he's angry at Nicole. Why? Because he didn't address her. But for another reason as well. As he sits there in the corner in the dark, he isn't watching the program on the stage. He's watching Nicole. Candace Garvey told you this, Denise Brown told you this as well, that whenever they looked over at the defendant, that he was not looking at the stage or the program on the stage or the kids dancing up on the stage. they told you that every time they looked over in that dark corner at the defendant, he was staring at Nicole. He was staring at Nicole, and that simmering anger that he had, folks, he was about to lose control. The fuse is getting shorter, and there's about to be an explosion. He is about to lose control. And he's about to lose control like he did on those earlier occasions. And sure, he didn't kill her on those earlier occasions in October of 93 or in 1989. But that was then, and back then the fuse was a lot longer. But now, the fuse is way short. It's awfully short. And when the program was over, clearly he knew that the relationship was over. In the past, he had done things to Nicole, and she had come back. But not only that, the Brown family. He still had the Brown family. But when you consider the evidence in this case, you see that after the recital, Nicole and the kids and the Brown family went to the Mezzaluna for dinner. They didn't invite him to go. He has been rejected, completely rejected. He has been rejected in public, and this is how these things work. You may sit here and think, oh, well, this isn't such a big deal. Well, sure. Perhaps in your lives and in your relationship, this wouldn't be such a big deal. But you have to put it in the context of the relationship that they've had. This is a big deal. It is a big deal to him. And he is rejected in public. They go off to dinner. He's left to go off to dinner with Kato Kaelin. He isn't used to rejection, by the way. He's a celebrity. We talked about that earlier. Celebrities get, you get the best tables. You always get everything you want. You get what you want. There are no rules for celebrities. But on June 12th, he isn't getting what he wants. And so he goes home. And the fuse is getting shorter. And it's getting shorter. And he talks to Kato Kaelin, and he complains about the dress she wore. And the fuse is getting shorter. Christian Reichardt was called by the defense, and he testified that he spoke to the defendant at 9 o'clock that night. And then when he spoke to the defendant, that the defendant was jovial, happier than he'd been in weeks. He went from simmering anger at the recital to jovial at 9 p.m. that night. Well, what happened? Why is that? It's because the defendant has developed a plan. He has come up with a plan to rid himself of the problem that has plagued him for 17 years. And he talks to Reichardt. He called Reichardt, as a matter of fact, if you believe that testimony. So many weird things going on that evening. He wants $5 for the sky cap. Kato gives him a 20. He's driving the Bentley to McDonald's. He's calling Christian Reichardt at 9 o'clock, and he tells Reichardt that he's packing. Right then, 9 o'clock, he's packing to go to the airport. That was the testimony from Reichardt. But then you have these other witnesses come in, Miss Orenthal Simpson and Gigi, the maid. They come in and they tell you that he always packs at the very, very last minute. He rushes around the house, and how everybody knows that he does that. What is going on here? Why is he packing now? Why is he doing these things with Kato Kaelin? Why is he jovial all of a sudden, if you believe Christian Reichardt? It's because he has a plan and he knows what he is going to do. He has had enough. The public rejection that day is enough. Folks, let me tell you, the fuse is so short at this point that he is about to explode. The next thing we know, he's in that Bronco. He is in the Bronco at 10 o'clock or earlier. We don't know when exactly he got into that Bronco, but we know that at 10 o'clock he's into that Bronco, and he is driving in that Bronco. And why wouldn't he be? How do we know that? We know that, as Ms. Clark said, because he keeps the phone in the Bronco, and he is panicked, and he is out of control, and he needs someone or something to help calm him. And so what does he do? He calls Paula. But he calls Paula in two places. He calls Paula at a 310 area code in LA. And she isn't there. Then he turns around and he calls Paula at a 305 area code. And she ain't there either. Paula Barbieri probably could have stopped this whole thing that night if she had been there to receive his phone call. But now Paula's gone, Nicole is gone, and whose fault is all of this? It isn't his fault. It isn't the defendant's fault. It's Nicole's fault. It's Nicole's fault. And that's... Even in 1989 when he beat her, when he came out of the house, he blamed her. Remember when he spoke to Edwards? He didn't want her in the house anymore. He had two other women. And then we come to find out that she found out that he had been with two women, and she was upset about that and wouldn't sleep with him. But he took it out on her. When you listen to the October 25, 1993 911 tape, he's blaming her because she had a relationship with a man a year and a half before, after she had moved out, after she had filed for divorce, when she was literally a single woman out there on her own. He always blamed her. Everything was her fault. And his breakup, his problems with Paula, the fact that he lost Paula was her fault. It was her fault because she went back and forth in terms of their relationship, and the fuse was short, and the fuse is about to explode. You're going to take a 10:30 break, Your Honor?
Yes.
And the bomb will explode when we come back. We're getting there. I've talked much longer than I'd ever expected. And I don't apologize for that because I think it's necessary that we have this discussion.
Keep your voice up just a little so I can hear, because you're turned away. Thank you.
So I apologize in a sense, I guess, but I have a duty and you have a duty, and I'm not going to have much of an opportunity later, I think, to talk to you. And so I wanted to share these things with you because I think they're important and because I think they may help guide you in your deliberations. But when we left off, we were talking about the fuse, how short the fuse was getting, and how the defendant was on his way to Bundy in that white Bronco. The same Bronco he drove that night in October of 1993. And so he's on his way, and he is panicked, and he is out of control, and he's calling Paula, and he can't find Paula. He calls her in LA, he calls her in Florida, she's nowhere to be found, he can't find her, he has lost her. And he has lost Nicole. And whose fault is this? It's Nicole's fault. He made a choice that day. He chose Nicole over Paula, and he lost them both. And so he arrives at Bundy. And Ms. Clark discussed with you yesterday the details of the murder, of both murders. And I don't want to, repeat all that she said. But one of the things that she said that I just want to elaborate on a little bit is his choice, his weapon choice, the use of a knife. This is a rage killing. And it is upfront, and it is personal. And that is why you see all the brutality that you see. Common sense tells us that. I mean, we know that just from life experience and from living in LA. We know what kind of killing this is. This is a rage killing. And he's using a knife because he is there to settle a personal score, a personal vendetta that he has. He stabs this woman in the neck, and he's right there. I mean, it's one-on-one. And the rage that he has, the anger, the hate that he has for her that night at that time, it's like it flows out of him and into the knife, and from the knife into her. Into her. And he kills Goldman, and he kills her in this rage. And let me make it clear to you. He's enraged, but He has made a conscious decision, a premeditated decision, a deliberate decision to go there and do what he is about to do to this woman. Otherwise, why would he take a big knife with him, right? He killed her that way because he wanted to make a statement. He wanted to teach her a lesson. He wanted to let her know. He wanted her to be there face to face to know just who it was who was doing this to her. With each thrust of that knife into her body and into Ron's body, there is a release, a small release. It's like a tiny time capsule, like contact. There was a release, a gradual release of that anger and that rage. And he stabs and he cuts and he slices until that rage is gone and until these people are dead. And after that rage is gone, he's better. One of the most remarkable things about this case is that after this man, after he did this to these two people, he didn't run away. He didn't jog away. Apparently he didn't limp away. You heard Agent Bonziak's testimony. He just walked away. He had released all of that rage and that anger during this homicidal fit he was having as he killed these two people. And I'm just a messenger. And I hate to be the one to stand here and tell you about these things, but this is a murder case. And this is what he did. All these things we talked about, these are the things that he did. This is how he lived. This is his life. Okay. And so I think we've come full circle at this point. We've shown you that he had the opportunity to kill. We've shown you that he had the motive, that he had a motive to kill. We've shown you in this trial that he was physically capable of killing. We've shown you that he had a reason to kill. We've shown you that he would have killed, could have killed, and did kill these two people. He's a murderer. He was also one hell of a great football player. But he's still a murderer. And so we've come full circle. There was Ron, and there was Nicole. And Ron, he was just at the wrong place at the wrong time. Nicole, she was in the wrong place for a long time. And there's this common factor, this common element between the two of them. The one thing they had in common was this man, this defendant. And so we began with them, two very much alive, vibrant human beings. We went through 1989 and 1985, through the beating he inflicted on her. And we went from that in 85 into 1989. And we came to this point on June 12 at Bundy. And so we've come full circle. And the only common element in all of this, and the only direction in which all the evidence points, is to O.J. Simpson. And I told you when this began that I had the hardest job. Nobody wants to do anything to this man. We don't. There's nothing personal about this. But the law is the law. And it applies to us. It applies to you. It has to apply to him. He made a promise a long time ago. He promised to love and to cherish and to keep her. He married her, and he made those promises to her. He promised to be her husband, and he was. And let me say to you that every wife killer or ex-wife killer starts off as a loving husband. And in every household where there's a marriage between a man and a woman, there's a picture just like that picture right there. There's a picture just like that on every mantle, in every home where the husband killed the wife. What he did that night on June 12th, the night of June 12th, to these two people, this brutality, is a violation of every law, high and low, that we can possibly think of. And I suppose there's some people that say, hey, we should cut him some slack. And, this were a case of, a theft or embezzlement or something like that, you can always make restitution. But this is a very, very serious charge. Two people are dead. And let me say that what you do in this case is entirely up to you. I mean, you're the jury. When I sit down, I sit down. I'm done. I've completed my duty. I've done what the law requires me to do. I have lived up to the oath, my oath, as a member of the district attorney's office. And we hope we presented the best evidence we could. And if we didn't present the best evidence we could, don't hold that against us. I just want you to, when the time comes to go into the jury room, I just want you to, somebody just say, let's calm down, let's elect a foreperson, let's read the law, let's take a minute and let's just look at the evidence. I'd just like you to use your common sense when you do. When you do that, you use your common sense when you try to be objective, when you remove all the emotion out of this case, when you remove all of the sympathy and passion, and when you just look at the facts, the evidence as best you can, you'll come up with the right decision. The world's watching. Everybody wants to know what you're going to do. Marcia Clark and I know you're going to do the right thing under the law. And whatever you do, the decision is yours. And I'm glad that it's not mine. Let me turn my attention and hopefully yours to the defense case, if I can talk about that a little while. They put on a defense. They called 58 witnesses. And they called 58 witnesses in this case, presumably to help raise a reasonable doubt in your mind as to the guilt of this man. And you heard from some real muckety-mucks, some real big shots in the field of science and forensic science and DNA, and you heard from Henry Lee. A real impressive group of experts, I suppose. But when you consider our case, you have to consider their case as well. And you have to assess the credibility of their witnesses just like you have to assess the credibility of our witnesses. And when it comes to assessing the credibility of witnesses, you apply the same standard regardless of whether it's a defense witness or a prosecution witness. You have to decide whether or not that expert testimony is worth anything or what it's worth. I hope that when you do that, I hope you keep in mind that, people made a lot of money testifying in this case. And you should consider that on the issue or question of whether or not those witnesses are biased. But study the defense case carefully. I insist that you do, as painful as some of it might be for you. But consider this. The defense that they put on in this case, it wasn't really an affirmative defense. It wasn't the kind of defense where they show you that he wasn't there. okay, at the time of the murder. They never did that. They never showed you that. What they did was they attacked all of our evidence. Well, not all of it. They didn't attack the domestic violence. There are lots of things that they attacked initially. Only to find out, of course, only for you to find out that, well, they didn't have a chance with it. But what you really wanted to know in that defense case, and I can't talk to you directly, but I'm going to assume you're reasonable people, you have common sense, good common sense, you're all successful at life. What you really wanted to know, correct? Maybe I'm wrong, but what you really wanted to know was where was he at the time of the murders, right? Where was that Bronco? Had they proven to you that that Bronco was not at Bundy, or could not have been at Bundy, that would have been very helpful to you. Would that not have been impressive to you? Isn't that the kind of evidence you want to hear, that you want to see? Credible, reliable evidence on that issue. That's the kind of evidence that raises a reasonable doubt. They didn't do that. They didn't put on that kind of evidence because they couldn't put on that kind of evidence. They don't have that kind of evidence. We all know where the Bronco was at 10:15. It was at Bundy. You would have liked to have known that some other person was with Nicole Brown or Ron Goldman, right? I mean, wouldn't you not have liked to have seen some evidence from some witness that the person that killed these two people was someone other than the defendant? When Mr. Cochran spoke to you during his opening statement, he talked to you about witnesses that he intended to call on. He gave you the names of those witnesses, and he told you what they were going to say. You know, and we did the same thing. I did the same thing. You know, in domestic violence, I told you I was going to call a few other people. I didn't. I think you got the point. You know, and I can't keep you here forever. Apparently, this sequestration thing is a real drag, right? And you'd like to end this experience, and I can understand that. But he promised to present to you the testimony of some witnesses who had they testified, could have perhaps raised a reasonable doubt in this case. So where are those people? Who are those people? Well, one of those people he mentioned was a woman named Rosa Lopez. You remember this in his opening statement? He said that Rosa Lopez was the maid that lived next door to 360 North Rockingham, and that she would come in here and testify that the Bronco was parked at 8 p.m. that night, the night of June 11th, that it was parked in the exact same place the police found it the next day. And that it was parked in the exact same manner. Tail sticking out. Remember that? He said he was going to present that testimony to you. He was going to call this witness. Well, where is she? Where was she? You would have liked to have heard that testimony, wouldn't you? He didn't call her. He told you about a woman named Marianne Gerchis, and he told you that she would testify that she was out on Bundy Avenue and that she saw 4 men running, 2 Hispanic men, 2 white men, and that a couple of the men wore knit caps. We have a knit cap at the scene, at the death scene. And that this happened at about 10:45. That's what the defense told you they would do. They told you they would call Mary Ann Gerchis to give you that information. And you may not remember all the names, but I'm sure you remember that when you heard this, that wow, the defense is going to call these people? Whoa, this is going to be some dogfight. I mean, these people are going to come in here and they're going to lay an alibi. Rosa Lopez is going to give an alibi for him by showing that the Bronco had been there all night. Marianne Gerchis was going to come in and testify that, hey, there were other persons, other men, apparently running from the area near 875 South Bundy. A few of them wearing ski caps, consistent with perhaps the real killer, a killer other than this man here. Did they call Marianne Gerchis? What happened to her? Where is that testimony? You'd want to hear that, wouldn't you? And right after they talked about Gertrude, they talked about a man named Tom Lang, who was supposedly down the street on Bundy, who also saw somebody. They told you that Tom Lang saw Nicole Brown standing on the street at Bundy, embracing someone. And that Tom Lang, as he stood there on the street, also saw a man standing some distance behind them, a man who appeared angry, a man standing there with his hands clenched, looking at Nicole and this other person, the person she was embracing. It's right there in the transcript at page 12,255. Where is that person? We already talked about Dr. Lenore Walker. Where's Dr. Walker? He told you Al Cowlings would testify. Where's AC? He told you that the defendant was out chipping golf balls. He told you Paula Barbieri was going to come in and testify about her relationship with the defendant. We didn't get Paula Barbieri. What do we get in terms of her relationship with the defendant? We got other people on the peripheral. The stuff you needed to hear to raise a reasonable doubt, and you're reasonable people. Never got presented in this case. It never got presented. What you got was a lot of smoke. You got people like Gertie's telling you that the crime lab isn't, can't be relied on. But then the substrate controls are all clean. You got guys like Professor McDonald out doing glove experiments where he's taking his own blood and then he's putting it on a new pair of Eris gloves and he's rubbing it around like this to see if they shrink. When you look at the defense in this case, you'll see that it really isn't helpful at all. It's all smoke. It really is all smoke. And you're going to have to be careful when you deal with that defense evidence. Now, some of it was pretty good, though. I mean, the stuff they did to Furman was textbook stuff from a legal perspective. But even that, you have to look and say, well, what does it do for us? It upsets us. But then you have to look at all the evidence and see how it's helpful, if it's helpful at all. They called demeanor witnesses, and witnesses to testify to the defendant's demeanor after the murders. And Marshall Clark talked to you about that. Murderers don't walk around with neon signs saying, I just killed somebody. When people do things, commit crimes like this one, especially a rage killing like this one, he will calm down. They will calm down. And they want to get away with it. He wanted to get away with it. So he certainly isn't going to do anything that's going to draw attention to himself. But they showed you these photographs. They showed you photographs of the defendant and some women at an event the night before the murders. Remember that? Because they had Carol Connor, the woman with the keyboard vest, come in and testify about the event the night before. Remember she told you that she witnessed an exquisite romantic moment between the defendant and Paula Barbieri. Well, what does that do for you? How does that help you resolve this case? It doesn't help at all, especially when you consider the fact that he and Paula had a disagreement, for lack of a better term, over his refusal to let her go to the recital the next day. But beyond that, it's a picture. He is at this big fancy event and somebody says, will you please pose with us for a picture? Well, when somebody takes your picture, what's the first thing they say? Cheese. What point is it? What good is it? What value is it in a picture like that when somebody's posing for you? And even in that video after the recital, he sees the video camera, he looks right toward it. posed for pictures are worthless. And they call that guy McKay. Remember Mr. McKay who worked for the AARP? Was it the AARP? Or the American Association of Psychologists or something like that in Chicago. And there was a golfing event, and the defendant came to the event as the spokesperson for Hertz. And Mr. McKay and the defendant and two other gentlemen took a picture together. They're posing for a picture. Not only are they posing for a picture, the defendant is basically at work. He's a spokesperson for Hertz. It's his job to go out and play golf with these people. So how does that help you? There is nothing in the record that establishes for you and I guess Dr. Walker could have done this. Whether or not, murderers have neon signs over their heads that indicate they're a murderer. How do you know? How do you know? Well, whenever you watch TV, you watch the news and some brutal killing happens and it's the neighbor. The neighbor did it. And they always interview the neighbors of the neighbor who did the murders, and the reporters always say, how was he? How did he act? What kind of guy was he? Oh, he was a nice guy. They always say that. You don't know. You can't tell. The testimony you heard about demeanor on the airplane and at the airport, it was a waste of your time, really. But if you want to attach some significance to it, you go ahead. It's up to you. I mean, you're the jury. I mean, the only demeanor really that's important is his demeanor that night. After he got into that Bronco and headed toward 875 South Bundy. But this defense that they've put on in this case, it's what we in the profession call a shotgun defense. And it's a defense as old as the law. Way back in the day, way back in the day, even back when I was in law school. Old lawyers and old law professors shared with us the old school approach to a criminal defense case. And every lawyer knows this case. You're a criminal defense attorney and you have a tough case. This is what you do. You argue the law. And if the law is against you, you argue the facts. And if the facts are against you, you raise hell and blame somebody else. When the facts and the law are against you, blame the police. Blame the prosecution. Point the finger elsewhere. Create a smoke screen. And that's what they've done in this case, ladies and gentlemen. Smoke and mirrors. That's it. That's what you've got. They put on those timeline witnesses. Remember Ellen Aronson and Danny Mandel? Judy Thielander. Pilnack. Remember Pilnack? Was she the woman that had 2 watches? If you haven't learned anything else about this case, I'm sure that you've learned that there are people who are banging at the door to get in on this case. Those people and the testimony they had to offer really wasn't helpful at all. I mean, Danny Mandel and Ellen Aronson were on a date, right? A blind date. They went to the Mezzaluna. They say that they walked past Bundy. In fact, Ellen Aronson gave an interview to the police the day after the killings. And she told the police that she passed Bundy at 11 o'clock. But once she heard about the prosecution's theory of the case, well, what did she do? She went back to the Mezzaluna. She talked to Mandel. They got together. And they attempted to reconstruct what they did that evening. She told the police she passed at 11 o'clock. Mandel told the police they passed between 10:28 and 10:32, and he knew that because he checked his watch. But even Mandel himself didn't know whether he had passed 875 South Bundy that night or not. He didn't know. He didn't know. He didn't know until, if it ever happened, he didn't know until he and Aronson got together and started putting their notes together, trying to do, as they say, to reconstruct what happened. His time in passage at 875 South Bundy contradicts her time. They got together on this story because they got together and attempted, as they say, to reconstruct what happened. What good is this testimony to you? And if they want to say they passed at 10:28 and there were no dead bodies out there, well, fine. I don't know how they can say that. I mean, they're on a date. They're looking at each other. That pathway is pitch dark, and we know that. We know that. Because when the bodies were discovered, the police were called, and Risky said he couldn't even see any bodies up that pathway. When he first arrived and got out of his car, he had to walk all the way up the pathway and use a flashlight. The only reason anybody found the bodies was because of Cato. And not Cato the human, Cato the dog. So how much attention were they paying to that particular pathway? There are lots of pathways leading to lots of condominiums on Bundy Drive. That testimony isn't helpful to you at all, but hey, do with it whatever you like. Then they called Francesca Harmon. Remember her? She testified that at 10:20, she was driving west on Dorothy. Okay, she's driving west on Dorothy, which is just south of Bundy. She got to Bundy and she made a right-hand turn. She didn't see any bodies. Then I asked her some questions. I said, well, when you made that right-hand turn at Bundy, did your headlights hit 875 South Bundy? I mean, did they sweep across the front of the condominium? What was her answer? No. I asked her, did your lights hit the gate at 875 South Bundy? She said no. And so I asked her this, well, did you tell the defense that your lights didn't hit the gate at 875 South Bundy? And what was her response? I didn't have to. They were in the car with me. They took her out on a test drive to have her show them the route she took that night. It was clearly apparent that she could not have seen what was in front of 875 South Bundy because her lights never hit the front of the location. And they called her to testify anyway. What does that say about the defense case that you heard? Well, it says they're desperate. That's what it says. We are not wedded to a 10:15 time frame, okay? The killings very well could have happened at 10:15, but they could have happened at 10:17 also. It could have happened at 10:21. We called witnesses to the stand to testify to the point in time that they first heard the wail of that dog, of Cato. Because we know that the wail was a plaintive wail. And we know that the dog was in distress. And so we know that something was happening, something very bad was happening to the dog's master. And if the dog is first heard around 10:15, I don't know. That may mean that the defendant is hiding outside and the dog here is aware of it. It may not mean necessarily that the killing happened at that specific time. It happened sometime around 10:15. We can't give you the exact time. We can't give you the exact time to the minute. If they want to push the time to 10:30, push it to 10:30. Because any way you look at it, he's still got time to get to Bundy, because we know he's in the Bronco at 10:03. He's got time to get to Bundy, to do these killings, and to get back to Rockingham by 10:54 or 10:45. Their witness, Robert Heitstra, told you that on a Sunday night, you could easily drive from 875 South Bundy to the defendant's house. And he knows that because Heitstra, he worked next door at the Salingers. Okay, he worked at the defendant's neighbor's house. He told you that you could drive there from 875 South Bundy with under 4 minutes on a Sunday night easy. So it doesn't make, makes us no difference. Makes us no difference at all as far as all of the timing is concerned. But they also called Denise Pilnack, the woman that wore 2 watches, and she came in here and showed you her 2 watches so that you would find her credible and believe her, because she wanted to get in on this case. Weird stuff. Weird stuff. But you, I don't know. She testified that she drove, what did she drive? No, she came home with Judy T. Lander, and she made some phone calls, and she kicked Thielander out of her house at a certain time and all of this. And how does she know, on all of that? How does she know that? Well, because 6 months after the murders, she put together this timeline. 6 months later. So how was that helpful? And then there's Thielander, and she's describing her drive up Bundy or around or near Bundy. And you know what's weird is that when you look at Thielander's testimony, and you look at Harmon's testimony, and you look at Heidstra's testimony, and you look at Pilneck's testimony, and you look at Aronson's testimony, and you look at Mandel's testimony, all of these defense witnesses, and what you see, what you come away with is this. These people are all at Bundy at the same time, basically. If you believe them, they are all basically on Bundy, at the intersection, or within view of 875 South Bundy. They're all there in this small area, basically at the same time. But when you talk to them, when they testify, they all tell you they didn't see any cars. They didn't see any people walking. They didn't see each other. Mutually exclusive. They mutually exclude each other. All of that testimony is they contradict themselves. They contradict themselves. And I'm not here to say these people are lying or whatever. They may just be mistaken. I don't know. But you have to evaluate their testimony, and I just think it's important that you take note of that. And I hope as well that you would take a look back at the timeline witnesses, if that's what we can call them, the ones that we called. Mark Storfer. He was concerned that the dog barking might wake his little boy, and so he told you what time it was. He looked directly at the clock, and he was interviewed the next day. The day after the murders. He knew what time it was when he heard the dog barking. Look back at Eva Stein. She lived in the condo directly above the walkway where the bodies were found. She lived right next door at 873 South Bundy. I believe her time was 10:20. Was it, Eva? Was it 10:20? It was 10:20. Those are the people you can rely on in terms of time. They're right there. They live there. They live right there near 875 South Bundy. But so you've heard the defense and you've heard the prosecution case, and as I said before, you're going to have to make the decision in this case, and whatever decision you make, we'll live with. But after I finish talking to you today, the defense is going to talk to you, and I don't know who's going to talk to you or who's going to talk to you first. I would ask that you listen, and listen as attentively as you have listened to me, apparently. But I'm going to ask you as well that you keep in mind that as you listen to them, consider this. Hope, at least, that they can somehow extrapolate from all the evidence we've heard in this case where the defendant was at the time of the murders. If he ain't the murderer, where was he? And maybe they can tell you that based on the evidence in this case. And they put on a defense and bear in mind and insist, I think, if they can, explain to you what happened to O.J. Simpson's Aris Light 70263 gloves. The gloves found at the murder scene, the same style of gloves purchased by Nicole, the same style of gloves you see him wearing in that January 6, 1992 game photo. Where are his gloves? They called 58 witnesses. They called the maid, Gigi Garain. They called Miss Arnell Simpson. If he never owned a pair of those gloves, I don't recall the defense asking him if he owned a pair of those gloves. I don't recall the defense asking the maid, the woman who kept the closet, who put things up, who did the laundry. I don't recall them asking her if he owned a pair of gloves like that. Like the ones we found at Bundy, like the one we found behind his house. And I don't recall him asking the maid whether or not he owned a pair of Bruno Magli's. Insist that the defense explain to you who kills two people wearing $200 leisure shoes, if it ain't this man, if it isn't this defendant. And I Ask him to explain to you why the bloody shoe prints leading away from the bodies are size 12, his size. And where did all that blood come from? And why is it that when he spoke to Tom Lang, he told Tom Lang that the shoes he wore the night before were white Reeboks? They put on a defense, and you would expect that if the man that Alan Park saw entering the defendant's house that night was not the defendant, you would expect them to have called that man to tell you that, hey, it was me. It wasn't the defendant. Right? And if O.J. Simpson didn't create or cause those stumps on the wall behind Kaylin's house, then who did? This is the defendant's property. And when Kaylin comes out with that flashlight, and when he finally sees the defendant sure doesn't seem too concerned about those stumps on the wall. I mean, Cato's frightened enough to grab a flashlight. He's frightened enough to tell the woman he's talking to on the phone that, hey, if I'm not back in 10 minutes, call the police. Worry about me. And words to that effect. But when he tells the defendant about these stumps on the wall, he isn't too concerned about it. He has West Tech security. We know that because the police talked to West Tech before they entered his house. Did the defendant call the police to say, hey, I may have a prowler on my property? Did he tell Cato to? Did he call West Tech, his private security, to come check this out? Did they? No. Why not? Because he knew. The defendant knew who caused the thumps on the wall. It was him. And why did he lie to Alan Park about being asleep? He wasn't asleep. And there are a variety of questions that you ought to insist be answered, that should be answered for you by the defense before you even consider acquitting this man of these very, very brutal crimes. The whole thing with the cut on his hand, what a fluke that is. You going to fall for that? They talk about cover-ups. That's a cover-up. That is a cover-up. A major, major question in all of this is what happened to that little black bag? Remember the bag on the driveway, at the driveway? The one that Cato offered to go get that night just before the defendant left for the airport? The defendant said, I'll get it, I'll get it. What happened to that bag? Has it been seen since? The defense well, we know that some of the luggage, apparently taken to Chicago by the defendant, was seized by retired Judge Delbert Wong. Remember? The Louis Vuitton bag? The one the defendant came back from Chicago with, the one he gave to Robert Kardashian. You saw it on tape. What happened to the little black bag? What happened to the contents of that Louis Vuitton bag? Remember? When you look at the tape, you see Kardashian standing there in front of the defendant's house. And you can tell that that bag is full. But when that bag comes to Delbert Wong, to Judge Wong, when it's pointed out to him, when it's seized by him months and months later, there's nothing in the bag. The bag is empty. What was in that bag? Ask him to explain to you why it is that if he didn't do it, why then is there a ton of evidence pointing to him and only to him? And ask him to explain to you, hey, if this is a rush to judgment, why then did the police go out to that house 8 times prior to 1989? Why didn't they ever arrest him? And if this is a rush to judgment, why did the police stand out in front of the house, in front of 875 South Bundy that night for a couple of hours doing nothing, as the defense has asserted, doing nothing but waiting for Van Adder and Lang? That's a rush to judgment. This is no rush to judgment. Unfortunately, this is just how things go. Those cops got out there to conduct a murder investigation, and that investigation led them to Rockingham. They followed the blood trail. Using your common sense, and when you evaluate all the evidence, you should do the same thing. Take a look at the crime scene and follow that blood trail. Because when you do, you're going to follow it right into his house, into his yard, into his bathroom, into his bedroom, right into his lap. And that blood trail went nowhere else. It didn't go anywhere else, and it didn't go to any other person. When I began this discussion with you last night, I talked to you about justice and what justice really means in this case. And it just means doing the right thing under the law. I mean, basically, that's all it means. Following his instructions. Just do what he tells you to do, the way he tells you to do it, and you'll be fine. And I've spent hours talking to you, and I've talked to you about the explosion, about that fuse, how the fuse gets shorter. We've explained to you that he had the opportunity and the means and the motive to do it, and that he did it. And we discussed a little bit about the smoke. We talked about the smoke the defense has put up. You have to find your way through the smoke. One of the first things they're going to tell you is that the prosecution's case lasted 6 months and ours lasted 2 months. They're going to tell you that. But you just keep in mind who was cross-examining those witnesses for days and days and days about minutia. About minutia. There was a lot of minutia in this case, and you know it was, because you didn't write it down. The defense got lost in minutia in their attempt to confuse you and to raise a reasonable doubt. Well, let me explain justice to you this way, and then I'll sit down and I'll be quiet. The people put on their case, the defense put on their case, and I assert that the defense case is a bunch of smoke and mirrors. It's all about distracting you from the real evidence in this case. So imagine the smoke, and imagine a burning house. Okay? Imagine that you're standing in front of a burning house, and from inside that burning house you can hear the wail of a baby, a baby's cry, a baby in fear, a baby about to lose its life. And you can hear that baby screaming. You can hear that wail. Now that baby's justice. This is baby justice. Now usually justice is a strong woman, but in this case justice is just a baby. And you hear that baby and you hear that wail and you see the smoke, you see the defense, there's all the smoke in front of you, and you feel a sense, you have a sense of justice. And you have a sense of what the law requires. And you have a strong commitment to justice and to the law, and you want to do the right thing. Well, justice is about to perish. Justice is about to be lost. Baby justice is about to be lost. And so you start to wade through that smoke, trying to get to that baby. You've got to save that baby. You have to save baby justice. And if you happen to run into some smoke, find your way through the smoke. And if you happen to run into a couple of defense attorneys along the way, just ask them to politely step aside and let you find your way through the smoke, because the smoke isn't over, okay? The smoke's about to get heavier because they're about to talk to you. Just use your common sense. Wade through the evidence, get down to the bottom line, and please do the right thing. It has been an honor to appear before you, and we will wait for your verdict.
Thank you, Mr. Darden. All right, let me see counsel without the court report, please. Ladies and gentlemen, that concludes the prosecution's opening argument to you. What is next is the defense argument. All right, the record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And as I mentioned to you, we had some preliminary matters we had to take up out of your presence. We're now ready to proceed with the defense argument. Mr. Cochran.
Thank you very
kindly.
Judge Ito, my colleagues on the defense, my colleagues in the prosecution, the Goldman family, the Brown family, to the Simpson family. Good afternoon, ladies and gentlemen. The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will. But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury, the longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago on September 26, 1994. I guess we've been together longer than some relationships, as it were. But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law. We all understand our various roles in this endeavor that I'm going to call a journey toward justice. That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you've stayed here more than a year, but will lie in the quality of the verdict that you render and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we ask you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. You know, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith that you live up to your promises. And I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services, and I especially appreciate them because sometimes I speak rather rapidly and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxham and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence? Please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things. But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you, please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet, but certainly in this great country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence. You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud, consider it a privilege to have been part of representing him in this exercise and this journey toward justice. Make no mistake about it. Finally, I apologize to you for the length that this journey has taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially who was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that. You've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut. Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that. Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing One of you is from Missouri, and he reminded you. Who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see. You've heard from the jury's instructions, and at the end I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them get away from their burden. My job, one of my jobs, is to remind you of that, and to remind them of that that's their burden. They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here. And we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said, but I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision. In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever in your life been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night, as I thought about the arguments of my colleagues, two words came to mind. And I asked my wife this morning to get the dictionary out and look up two words. The two words were speculative and cynical. Let me see if I can get those words that she got from me. Excuse me one second. I asked her, as I was thinking about this case, to go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life. And to speculate, to engage in conjecture and to surmise, or is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12th, 1994, after 10:30 or 10:45 in the evening, so that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see it's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view. Now, in this case, and this is a homicide case and a very, very, very serious case. And of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does in fact happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides. They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass, they were more concerned with their own images, the publicity that might be generated from this case, than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But your verdict in this case will go far beyond the walls of Department 103, because your verdict talks about justice in America, and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently. Remember, I told you this is not for the naive, the faint of heart, or the timid. So it seems to us that the evidence shows that professional police work took a back seat right at the beginning. Untrained officers trampled. Remember, I used the words in the opening statement. They traipsed through the witness, through the evidence. And it was interesting because the prosecution didn't agree with that at the beginning, but later on in this trial, we heard Mr. Goldberg and talking to witnesses use my words, traipsing through the witness scene. That scene there at Bundy. He used our words because they understood. We knew what we were talking about. We were able to demonstrate it through the videos. They delayed unconscionably routine procedures in notifying the coroners. They didn't call the criminalists out on time. And yes, they allowed this investigation to be infected by a dishonest and corrupt detective. They did that in this case, and they may try to back away from it all they want, but that's very important, as you're going to see, to this case and the resolution of my client's innocence. Because of their bumbling, they ignored obvious clues. They didn't pick up paper at the scene with prints on it. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man. And they never, ever looked for anyone else. We think if they'd done their job, as we have done, Mr. Simpson would have been eliminated early on. And so this case is not, let me say at the outset, is not about attacking the Los Angeles Police Department. We're not anti-police in making these statements. You're not anti-police. We all need the police. I just said we have so much crime in this country, we need the police. But what we need, and what we must demand, what all of us should have, are honest, effective, non-biased police officers. Who could demand less? Can any of you say that's not what we should have? And so, let me tell you about how we're going to proceed here this afternoon. The defense has one opportunity, basically, to address you. This is after the prosecutors are finished. I will address you first, and after I'm concluded, and I will talk generally about the lay witnesses and an overview of the evidence and what you've heard. I'll strive not to bore you. I'll strive to be honest in my discussions, to be relevant, to be concise in what we talk about here. When I'm finished, Mr. Barry Scheck will come before you and address some of the forensic issues. And then finally, after Mr. Scheck finishes, I'll come back and conclude with some concluding remarks regarding what you've heard over the course of the last 2 days at any rate. Now you understand that because the prosecution bears the burden, in this case and in all cases, Ms. Clark will argue last to seek to rebut that which we bring up. And presumably she won't be back up here talking about all kind of new things. Seek to rebut that which we bring up. And let me tell you in front, if she brings up anything, we may be precluded from standing up and saying, wait a minute, Your Honor, here's the answer to that. But you can then substitute your common sense, your judgment in that place. And that's required in this journey toward justice. Now, at the outset, let's talk about this timeline for the defense. I said earlier that Mr. Darden did a good job in his argument. But one thing he tended to trip over and stumble over was when he started to try to talk about our case. He doesn't know our case like we know our case. It was interesting, wasn't it? Because first he stood up and started talking about the timeline being at 10:15. Then he said, well, they didn't prove anything, but golly, well, it may have been as late as 10:30. That's interesting, isn't it? Never heard that before. You look back and see what Ms. Clark promised you a year ago. 10:15. 10:15 was all they talked about. And they were going to use, because of the incompetence of this investigation, the wail of a dog. So we've been relegated to, in this case, because of this very, very poor investigation. But having said the defense doesn't have to prove anything, in this case, we did, in fact. And so Mr. Darden could talk all he wanted to about his theories about motive. They're just that, his speculative theories about motive. But when he came down to the end, he wasn't talking about motive, was he? He was trying to talk about our timeline. Why would he do that? Let's talk about why he would. Because the defense in this case called many witnesses who corroborate each other and who shatter the prosecution's timeline. Now, these are witnesses to a person who were known by the prosecution but discarded by the prosecution. Why? Because they didn't fit their tortured, narrow window of opportunity. So when you would visualize for me that jigsaw puzzle, where they want to reduce this case down to a jigsaw puzzle, the part that deals with opportunity is the timeline. And we're going to start off with that, because in a search for truth, let's look for the truth. Not some contorted, twisted truth, but the real truth, the facts that you've heard during the course of this particular case. We think after you look at this timeline for the defense, you will agree with our early analysis. This is a case about a rush to judgment, a case where there's been an obsession to win at all costs, and in the words of Dr. Henry Lee, something is wrong with the prosecution's case. Let's start off with Francesca Harmon. Francesca Harmon is the lady who left the dinner party on Dorothy at about 10:20 p.m. She drove west on Dorothy and Bundy and turned north on Bundy, so she'd be heading north toward 875. She saw nothing Heard nothing. No barking dogs. It's a lady known, of course, to both sides. And so you see this graphic regarding Francesca Harmon. And I think to familiarize you with that, I think at 10:20, so I understand that's the approximate time that she would pass by or near Nicole Brown Simpson's home there. Well, you see it with the X mark there in this graphic. That's Miss Harmon. We followed Francesca Harmon with Ellen Aronson and Dan Mandel. Remember the two people who'd been on their first date? They'd gone to Mezzaluna. And they were interesting young people. I think you would find them credible. And by the way, you hold all witnesses up to the same standard. No side has a priority on the truth. These are witnesses known to both sides. We're the ones, however, who elected to call them and bring them here for you. You know how they walked home from this first date at Mezzaluna, walking directly by the walkway at 875 South Bundy. And they said they passed by there. Remember, they were clear. They passed by there at 10:25. And you'll see the little kind of purple lines. Shows you the route they took. So they passed right in front of Miss Nicole Brown Simpson's home at 10:25. And you remember, they continued on. So they were over on Darlington Street by 10:29. She said that it took them about 4 minutes from the time they passed 875 South Bundy to get home that evening. This was their first date, and I guess, as I recall, this was also their last date. They saw no blood. They saw no barking dogs. I submit to you, if the bodies had been there, they could have been seen. Now, why do I say that? I say that because we have a contact print in evidence. And I'm going to ask Mr. Harris, if he can, to show us this contact print. This is an item you'll be able to take back in the jury room. Now, this is a photograph taken by Mr. Rokar at night, and it will let you see, Mr. Harris gets it focused, that scene that particular night, what you could see with regard to this body. And Your Honor, you may want to cut the feed on part of this. $33, Howard. This exhibit number 86 was a photograph that we got late in the trial of Mr. Rokar. The photographer was called by us. You see that document over there? That's a contact sheet. Remember, he talked about all of these photographs in sequence in this first roll were taken at night. This is going to be a very, very important role for you as this case progresses. This is a photograph at night of what you could see from across the street, and there were lights in and around there. And so when Mr. Darden stands up here as an advocate and tells you it was pitch black and you couldn't see anything, this is the photograph that was taken before the sun came up. This photograph was taken at night. It's not pitch black. We know also that according to the evidence, blood had flown down that walkway. There were bloody paw prints that went southbound on Bundy there. So you see that photograph? You see that photograph? Now you can be an advocate, and we're all sworn to do the right thing. He talked about his oath. Well, your oath is also to tell the truth. It's not pitch black. We have the evidence. And I'm going to try to do that throughout. Where they have misled you or not said things that weren't correct, I'm going to try to straighten it out for you. Mr. Harris, why don't you tell the court now what that number is? This is number 1369, and that's Mr. Rokar. We're going to come back to some other photographs on that, but you'll recall his testimony. And the reason why 1369 is so important is because it is undisputed that at 10:25, Mandel and Aronson walked past there. If there was blood down on that sidewalk, if there had been a killing had taken place, if there were dogs barking or wailing, don't you think, given that, if you've been out there, you'd see it. So the time has come now to stop all this folly and fantasy. Let's deal in reality and in the facts of what took place and what you can see with your own eyes. I don't want you to speculate or theorize. When I sit down, I want you to understand what the facts are of this case. Hey, Mr. Harris, you can take that down. After that, we had Denise Pilnack and Judy Chilander. You know, and I think, again, as advocates, we have a responsibility to treat all of these witnesses with respect. These people didn't ask to come down here. These people don't ask to be maligned. I don't think anybody really wants that, with the exception of one or two. And most of them were called by the prosecution. So when Denise Pilnack, the lady who wore 2 watches, comes in here and tells you, I ask you to judge her credibility like you do all the witnesses. The court has instructed you. You hold all witnesses up to the same standard. You look at the reasonableness of what they have to say. You look at their bias or interest. You look at their demeanor on the stand.